Hello everyone, welcome back to Kalam Academy. I am Rajesh Vats and I will be taking up this case snippet session for the Polity section. Last year this case snippet session was very successful. 10 plus questions was there in the UPSC Prelims directly, right. So this year we are expecting more number of questions. Exact how many questions there will be, so no one can guess, it's only UPSC. So only after the prelims that can be there, but it's sure short that significant amount of questions will be there from this booklet, because this booklet is very exhaustive in nature, right. Most of the topics which was there in last 15 months of the news, so that has been already covered, right. You must have seen several sessions also, like the history, like economy sections, right. And here we will be discussing with the polity section. The main motive of this session is to revise, right. It is not to give you foundation knowledge or the basic knowledge, right. At this point of time, I understand that each of you must already have learnt, right. You must have learnt from the Lakshmikant, you must have learnt from the other current affairs booklets, right. So what we will be doing, within the limited time period, we will be revising those things, and while revising, we will be looking up those facts which are most often asked by the UPSC prelims. For example, whether anything is written in the constitution or not, whether anything is constitutional body or statutory body or non-constitutional, non-statutory body, right. Whether what has been different kinds of provisions, what has been the provisions in the business rule of the Lok Sabha, Raj Sabha. So such kinds of things we will be looking up and specifically pinpointing whatever will be necessary for the prelims, that we will be covering, right. So let's start this session, and I hope you watch this session till the end, because you cannot expect that which topic will be coming. Each and every topic mentioned in this booklet, so that are very important. So do not judge that if you have watched like 1 hour of the video, so that is enough. So if you have watched 2 hours of the video, that is enough. Please watch, give all your time, and investing time on this video is very significant, and it will be helpful for you for in the UPSC Prelims 2024. So with this vision and with this mission, let's start the discussion of case snippet session, and hopefully we will be looking up questions from this session in the UPSC Prelims 2024, just like the last year sessions, right. While dealing this topic, we will be going through in the recent months, like that is April and the March months first, and after that we will be going through a sequence, syllabus types, right. So and for the polity section, one thing is that whatever the issues is there, so that issues may not be very important for you, right, because that issues may be asked in the UPSC mains exam. But whenever any issues comes in the news, then you will have to understand the basics related to that, and if any significant things has been issued in that issue, right, by some Supreme Court judgments or anything, any reports has come, so that we have to understand. So looking into such perspective, we will be covering this session. So let's start this. So the first article is the candidate's right to privacy versus the voters' right to know. So this was in the news because in the Supreme Court such cases has been filed that whether election candidate whether they have to give all the details, each and everything, all the clothes, all the shoes they wear, so each and everything they will have to give the details or not, right. So if you look, the Supreme Court judgment has said that the candidate's right to privacy is over the right to information or the right to know of the voters, right. So not each and everything has to be given in the details, because each candidate has to give some details, right, how much asset they have, how much liability they have, right. So such things are there, but not each and everything has to be covered. I hope you are able to see this. Okay. So the Representation of Peoples Act 1951, under the section 23, you don't under the section 123, it deals with the corruption related things. You do not need to remember these sections for the prelims point of view, but you will have to remember this section for the mains point of view, because Representation of Peoples Act 1951 is clearly written in your syllabus. So section 123, it says that it defines the corrupt practices. These corrupt practices include the bribery, undue influences and the false information, and such kinds of things, it will be coming under the corrupt practices. Then the section 75A of the Representation of Peoples Act, it says that every candidate election for a House of Representation shall within the 90 days from the date of which make and subscribe an oath, means every candidate will have to take an oath after they get selected, right, after they become the member of parliament or the member of legislative assembly. So within 90 days of taking that oath, so that candidate will have to submit all the related information, that is what, how much asset and liabilities they are having. So such kinds of information has to be submitted, right. And section 100, it declares the ground for declaring this election to be void. If anything which is very significant that it has not been mentioned, for example, if someone is having very expensive watches, very expensive cars, right, so that will be an asset, so that has to be mentioned no matter what. But inexpensive things like the shoes, clothes and small items in the kitchen or the utensils, so such kinds of things is not need to be mentioned. So this is what the Supreme Court has said in this candidate's right to privacy versus right to know, right. And the use of word is there, defect of a substantial nature, defects of a substantial nature, right. So that is there. Another article is custodial death in India. So in India there are lots of people who are under trials and they have been in the custody, right, and as they are in the custody, they are under the trials. So like Indian jails, the prisons, so all these prisons, all the jails are like overcrowded, and therefore many a times custodial deaths happens. So if you look at the statistics, then highest number of custodial deaths have been reported in the Gujarat, followed by the Maharashtra, Uttar Pradesh, Tamil Nadu and the police. One thing you have to remember here is, for the prelims point of view, what is the difference between the custodial death, means what is the difference between the police custody and the judicial custody, right. So police, in the police custody, the police will be arresting some person and they will be keeping them in the jail without any permission of the magistrate. But in case of judicial custody, the permission of magistrate is very much required. Without the permission of magistrate, the police cannot arrest a person, right. Just a second. So that is there. Then in the police custody, the accused is kept in the lockup, right. The police has already captured it, they will be keeping up the locker. And one thing is very important, that if the person is in police custody, so within the 24 hours, the person has to be brought in front of the magistrate, and if the magistrate agrees, right, for more permission of these persons for more judicial custody, right. So in that case, the police means, in case of police, within the 24 hours, the person will have to brought in front of the magistrate. But in case of judicial custody, as it is already been given by the judges, so it will be for some limited time period, means judiciary itself will be saying for how long this judicial custody has been there, right. And one very important is there, in the police custody, interrogation can be possible. First degree, second degree, third degree type of interrogation is possible, but in the judicial custody, without the permission of judges or the magistrate, interrogation is not possible, right. So that is the difference. If you look at the constitutional provisions, then Article 20, Article 21, Article 22, so such these kinds of articles, it covers such kinds of fundamental rights, which includes, like the Article 21, it is right to life and personal liberty. So a person has a right to bail, a person has the right against the solitary confinements, right. A person has the right against the inhuman treatments. So such kinds of things support that there should not be unnecessary judicial custody, or there should not be unnecessary like this police custody, right. So that has to be ensured in a democracy. Several provisions are there that the Indian Police Act is there, in which the police personnel can penalize, police officers and police personnel can be penalized, suspended or dismissed if they have done unnecessary arrest or detention of a person, right. So that provisions is there. Article 20 also, like no ex post facto, no double jeopardy, no self incrimination, all of this I guess you must be knowing. So these kinds of things will also be in support of the arguments that unnecessary judicial custody or the police custody should not be there. A person has the right to life and personal liberty, so that person should be freed. Another article which was in news was Center versus States clash over the relief fund. So why was it in news? Because several states are there which is opposition ruled state. So those states are facing the difficulty because states is not relieving the disaster relief fund on timely basis, right. Many times there has been lots and lots of delay. So to stop that delay and to release that fund, these states have reached to the Supreme Court time and again, right. So this issue is not important for the prelims point of view, but you will have to now understand what is this relief fund, from where it comes. So this relief fund comes under the Disaster Management Act 2005, and under the Disaster Management Act 2005 there is provision under section 46, you don't need to remember. So there is a provision of National Disaster Relief Response Fund, and it will be administered by the central government. Every state will have the State Disaster Response Fund also. So in addition to State Disaster Response Fund, this National Disaster Response Fund will be allocated, because most of the times the disaster will be coming in the states only, right. So that will be there under the section 48 1A of the this Disaster Management Act has been there. So this thing is there. These states have reached directly to the Supreme Court. How it is possible? It is possible through the Article 131 of the Constitution of India, right. Article 31 of the Constitution of India provides original jurisdiction to the Supreme Court, and through this original jurisdiction, if there is any clashes between the states or the center, or between the state and few states and the center and the other states, or between the two or more states along with the center, so such kinds of issues can be taken up by the Supreme Court only, right. So it is a original jurisdiction. States can directly reach to the Supreme Court. So in such kinds of cases, the Supreme Court has the original as well as the exclusive jurisdiction, right. So that is there. Several commissions have recommended, like the 10th Finance Commission, like 15th Finance Commission have recommended about the disaster management. Just like the 10th Finance Commission, it has recommended that how do you understand whether any disaster is a national disaster or not, or what has been the intensity of the disaster, right, whether at the national level this can be called as the disaster or not, right. So they have used the term like the calamity of the rare severity. So when will you call a disaster as a calamity of the rare severity? So it can be called on the basis if the intensity and the magnitude of the calamity is very, very high and level of the assistance needed is very, very high, because state disaster response fund will not be sufficient enough to tackle such kinds of disaster, right. So in this scenario, what is the requirement? Then there is requirement of the National Disaster Response Fund also, means at the national level disaster relief fund should be released also, right. Plus the capacity of the states to tackle the problem. What are the capacity of the states? The states has the State Disaster Response Fund. So whether that State Disaster Response Fund is capable enough to tackle that disaster, for example tsunami of 2004, Uttarakhand flash flood of 2011. So such kinds of disaster cannot be tackled by the State Disaster Response Fund. There has to be release of the disaster relief fund from the center through the National Disaster Relief Fund. So that is there. 15th Finance Commission had recommended regarding the mitigation. National Disaster Response Fund occurs when disaster has already taken place. But mitigation will occur when disaster has not taken place and you are working to not letting the disaster happen at the first place, right. So that is mitigation. So 15th Finance Commission has called for the National Disaster Mitigation Fund, and it said that it should be in the targeted manner, means in those area where there has been lots of drought, where there has been lots of flood, seismic zones is such that there has been lots of earthquakes, right. So flooding is there, erosion is there. So target those area in different states and give a specific mitigation fund regarding that. So this is the recommendation of the 15th Finance Commission. National Disaster Mitigation Fund and the State Disaster Mitigation Fund, they have been talked about. Now, Supreme Court ruling on the bail condition, right, means which kinds of person can be given a bail. Bail, you know, if any person is arrested and till now he has not completed the trial, or till now the person has not completed their complete punishment, so that person will be seeking bail, right. So bail, if you see the concept, what does this bail means? So bail refers to the temporary prison release of a person awaiting a trial or an appeal. So there can be different kinds of cases regarding which the bail can be seek. A person can seek a bail for the bailable offence, means those offence which are bailable, in which the bail will be easier to get, and those there can be non-bailable offence also, and in that scenario also, even if the offence is non-bailable, in that scenario also sometimes bail can be provided, bail can be given. So what are the difference? In bailable offence, there should be sufficient reason should be to believe that the accused has not committed the offence. If it is proved that the accused has not committed any kind of crime, that person has to be released from the jail, right. So that person will be released. So that will be the case. Then if the sufficient reason is that there is to conduct further inquiry into the matter, if it is required that the further conduct is required, further inquiry is required, but for the time being the person can be released, so that person can be released here. And the person is not accused of any offence punishable with the death, life imprisonment, or the imprisonment up to 10 years. So if a person has committed any kind of offence for which that person will be getting the punishment of at least 10 years, then that person cannot get the bail, because in that case most of the cases will be covered that will be non-bailable in nature. And for the non-bailable section, for the non-bailable offences, there are different kinds of provisions for getting the bail. For example, in non-bailable offence, the bail may be granted if the accused is a woman or a kid. If the person is woman or a kid, so in that case the bail can be granted if there is a sufficient proof that the person has not committed the crime, so that person can be released, that person can get the bail. If the complaint delay filing a FIR, if the person has been put into the jail but still the FIR has not been filed, right. So if the FIR would have been filed, so that case would have been a non-bailable offence. So on the basis of that the person has been captured and has been kept into the prison, right. ऐसा भी होता है. So if the accused is seriously ill, in that case also the bail has to be provided on the humanitarian grounds or the human right basis, right. So that is there. Supreme Court has given the judgment earlier in 2009. Now these kinds of Supreme Court judgments you do not need to remember for the prelims point of view. The UPSC will not be asking any Supreme Court judgments unless and until it is very important, like the Keswanand Bharti case. So in that case the Supreme Court may ask, but these kinds of judgments like the Kilari versus the state of UP 2009, so such kinds of Supreme Court judgments is not much necessary for the prelims point of view, right. The Supreme Court observed that while exercising its discretion to release a person on bail, the court must ensure its act judicially. It is also ruled that the appellate court must record its reason while granting a bail. So such is the provisions provided by the Supreme Court. So I hope this thing is clear to you. The next thing which we have to discuss is Model Code of Conduct. Now what is this? Recently the Lok Sabha election has been announced on the 16th of March 2024. From that day itself the Model Code of Conduct got applied. Why? Because the Model Code of Conduct gets applied on the date on which the election is announced by the Election Commission of India, right. Whether it is for the Lok Sabha, whether it is for the State Legislative Assembly, right. So that is there. Now up to when Model Code of Conduct will be there? So Model Code of Conduct will be there till the election result is being declared, right. So that is there. So this is the time period for which the Model Code of Conduct will be applied. So in the Model Code of Conduct, this is a code, right, which has to be, in which the several provisions has been written, and these kinds of provisions has to be fulfilled by the various political party or even the individual candidates who is fighting the election, who is contesting in the election, right. So that is a Model Code of Conduct. So it is just a set of guidelines issued by the Election Commission of India to regulate the behavior of the political parties and the candidates during the election. Whether there is any statutory backing, whether it is written in the Constitution of India. So Model Conduct of India, Model Code of Conduct is not written in the Constitution of India. It has no statutory backing. The students may get confused that the Representation of People's Act must be writing the Model Code of Conduct. It is not the case. The Representation of People's Act is not writing about the Model Code of Conduct, right. So it is neither statutory thing, or it has no constitutional backing also, right. So what happens when the model codes of conduct is applied? So there are several kinds of instruction which is given to the political parties and to the candidates, which has to be followed. For example, if any kind of criticism has to be done, then that criticism has to be done on the basis of what? On the basis of policies, programs, yeah, on the basis of past record whichever the political party was there earlier, right, but not on the basis of caste lines, communal lines, religion line. On that basis this criticism cannot be done, right. Several other things are there. For example, if any party is going to conduct any kind of like the any political party is going to conduct any kind of rallies, right. So they will have to take the permission, or they will have to give information to the local authority, so that those rallies could be conducted in a peaceful manner. There should not be any kind of communal violences which should be erupting, right. So that intimidation by the party to the local authority, local police authority, is very, very important. So that is there. Several other kinds of provisions are there, that on the polling day, where the polling booth is there, so near to that only those person can go who has the valid voter ID, right, who is going to vote, or who has the some kind of ID is there which has been issued by the Election Commission of India. So only those persons will be allowed to go there, right. Plus several other provisions will also be there, means those who are in the those party who are in the power. So there will be lots of restriction on them, means they cannot issue a new program or policies altogether during the model code of conduct, right. So this is why there is need to have a simultaneous election, because in our country election happens time and again. Every year 4-5 states has an election, right, and in those states wherever there is election, 3 to 4 months of the time is wasted, and in this model code of conduct itself, right. In the Lok Sabha election it will be larger, for in the Legislative Assembly election it will be smaller, right. So that is there. So ministers, those party who are in the power, so they will also have some kind of restrictions, like those ministers who has got the public vehicle provided by the government of India, so they will not be used in the rallies, they will not be used in the means for the election purpose. That should only be used for the means whatever the function that minister has to perform, right. A party must avoid spending money on the advertising or using official mass media to publicize its accomplished, and there are also social media guidelines also. So such things has to be followed. So it is a long list actually, model code of conduct. All you have to understand is the concept about the model code of conduct and whether there is any statutory or the constitutional backing or not. UPSC will be more likely restrict the question related to this information only, right. So next thing which was there is PM Suraj portal. So Prime Minister launched the Pradhan Mantri Shramik Utthan Evam Rozgar Adharit Jan Kalyan portal for the credit support to entrepreneurs from the disadvantaged section of the society. So most of the times what happens, that this disadvantaged section of the society, SC/ST population or the other women section, right, the farmer section, right, economically weaker section, so such kinds of people, they have no access to the credit. So this portal will help in providing the credit facility to these kinds of disadvantaged section of the society. So it will set up a one-stop point where the people from the disadvantaged section of the society can apply for and monitor the progress of all loans and credit schemes already available to them. Right. So that will be the case. Not very much important. Many times UPSC asks this mnemonics, means what does this PM Suraj is related to. They will be giving 4 statements, right. So out of those 4 statements, you should be able to recognize that which statement indicates PM Suraj. So definitely it will be related to the disadvantaged section of the society, and it is regarding to the credit support to the entrepreneurs. This much information is more than sufficient to answer the question if such mnemonics types of question is being asked by the UPSC, right. So that is there. The next article which has been there is bribe for vote case. So what is this bribe for vote case? Many times it has been discussed, right, because the parliamentarians or the person in the state legislature, they have the privilege, right, and they have the privilege to right to speak, right to vote in the house. So does that mean that the person will take the bribe and for that they will be voting in the parliament or the state legislative assembly? No, that is not possible. Earlier it was allowed. Recently the Supreme Court has given a judgment that now the bribe for vote will not be allowed. The 7-judge constitutional bench has given this judgment, because under Article 105, under Article 194 of the Constitution, the Article 105 gives the parliamentary privileges to means the member of parliament will have the privileges like the right to speak, right to discuss, right to vote inside the parliament. Similarly, Article 194 of the Constitution of India, it provides privileges to the member of legislative assembly, right. So such kinds of things is there, but this does not give immunity on the bribery. This does not mean that a person will be taking the bribes, they will be demanding something in the cash or the kind, and for that they will be voting in the parliament or the state legislative assembly. So that is not possible. There is need for the necessity test of the twofold test. The Supreme Court had said that whether a case is there for the bribe for vote case or not, so that will have to go to essential test. Whether the individual right of the parliamentary privilege has to be pass a necessary test of twofold. The first is essentiality. It means that for a members to exercise a privilege, the privilege must be such that without it they could not discharge their function. So essentiality test says that if anything is very essential, that has to be provided to those persons, to those member of parliament and to those member of legislative assembly, right. So if anything is very essential, that has to be provided, and if it is that essential that the member of parliament or the state legislative assembly could not discharge their function without that, so such things has to be provided compulsorily. So this test will be passed and need to discharge the duty whether the privilege claimed is necessary to discharge the essential duties of a legislature. A legislator has some kind of essential duties, for example, right to speech and expression inside the house, right to freely discuss, right to vote on their own, right. So such kinds of things are there, but the thing is it will take the need to discharge the duty. So whether whatever the things, what the rights they are getting, member of parliaments and the legislative assembly, so whether that is required to discharge their duty or not. So such kinds of things is there, and definitely if you see the bribe, right, taking bribe is not an essential thing. Without taking the bribe also the person can vote, right, as per their own will, as per their own wish, as per their own knowledge, right. There is no need to have external influence. So this bribe for vote will not be allowed, and there is no immunity on the bribery. So that is the case. And if you take the corruption related regulations or the laws, then the section 7 of the Prevention of the Corruption Act, it also covers this corruption related things. It says that it deals with the offence relating to the public servants being bribed. So if any public servant, merely if they are obtaining or attempting or accepting, right, bribes, then that will be considered enough that bribe has been taken. So even if they are attempting to take the bribe for anything, so that will be considered as a act of bribery, right. It is not necessary that the act for which the bribe is given be actually performed, right. So even if a person has taken some bribe, right, and that person has not done that work for which the bribe has been taken, so what will you consider in this case? Will it be bribery or not? This act says that this will be also be considered as the bribery, even if the person has taken the bribe and that person has not done such things for which the bribe has been taken. Bribery has been conducted, and that will be, the person may be punished for that thing, right. So this was the bribe for vote case. Another thing which was in news was the declaration of electoral bond as unconstitutional. So this was like hot topic. The Supreme Court has recently struck down the electoral bonds. What is electoral bond? So electoral bond, it was like the, if any person or any institution or any organization, they wanted to fund for the election, right, they wanted to fund to any political party, then they will be purchasing these electoral bonds, and they will be from the State Bank of India, and they will be submitting that bond to their political party, whichever party they want to give, right. Within the 15 days of taking that bond by the political party, their party will be submitting it to the State Bank of India, and within the dedicated account opened for this electoral electoral funds, the political parties will be submitting that thing into their, the SBI will be submitting that electoral bond money into their political party's account. So that was the electoral bond. It could have been purchased on the denomination of rupees 1000, 10,000, 1 lakh, 10 lakh, 1 crore, right, and it could have been purchased only through the State Bank of India. And one very important point was there, that this bond was anonymous in nature. So there was nothing written, no name, no profession, nothing was written on this electoral bonds, right. So it was just like a promissory note. So whoever is having that note, whoever is having that electoral bonds, so that person, that political party can take up that money from the SBI, right. So there was no purchase limit on the number of bonds, and if within the 15 days the bonds was not being submitted in the State Bank of India by the political parties, so that amount would go into the Prime Minister Relief Fund. So such kinds of provisions were there, but the Supreme Court has recently struck down this electoral bond, saying that it is unconstitutional in nature because of its anonymity. Supreme Court has said that whatever the electoral funding is coming for any political party, so it is the voters' right to information to know from where that funding has come, right, and therefore as this was violating the right to information of the voters, therefore this electoral bond has been made unconstitutional in nature, right, because it was hitting the right to information of the free speech and expression. Because if a voter does not know that who is funding which political party, which kind of person. Maybe some terrorist is funding some political party, right? Maybe some ill-minded person is funding some political party with some kind of wrong intention, and if you are voting that political party and that political party wins the election, so the nation may be in danger. So it is under the right to information of the voters that such kinds of electoral bonds has to be highlighted. So therefore this has been done along with the Supreme Court, along with the Supreme Court judgment, whatever the amendments which has been brought by the when this finance bill has come in 2017 for bringing this electoral bond. So all those amendments has been made null and void. So all those amendments has been struck down also, right? So that was the issue. Another thing is Ladakh demands full statehood, right? Ladakh you already know. So Ladakh was a part of Jammu and Kashmir only, right? And with the Jammu and Kashmir Reorganization Act 2019, the Ladakh has been made the union territories separated from the Jammu and Kashmir, right? After that the Ladakh has been made a union territory. So there has been lots of tourism propagating in this Ladakh region, and lots of investment is rushing towards the Ladakh region. Because of this there has been lots of environmental issue, and the people of Ladakh is very much concerned about this. So what they want? They want that proper statehood, full statehood should be provided into the Ladakh. Instead of union territory, they want the full statehood, right? Several protests has been there, right? Sonam Wangchuk has done 21-day protest in support of the Ladakh being made statehood, right? So that is there. So this is, and Ladakh, you know that it is a Muslim majority union territory in which the Leh district dominated by the Buddhist and the Kargil by the Shia Muslim. So for the culture point of view, this point is very, very important. Now they are also demanding 6th schedule status, right? Now 6th schedule status, why do they demand it? Because the 6th schedule status is there currently in 4 states only: Assam, Meghalaya, Tripura, Mizoram. And wherever this 6th schedule applies, the people of that region gets more autonomy, because they will have to form, there will be a autonomous district council running there, and those autonomous district council, they will be like making plans, developmental projects, they will be issuing all those things, right? Like the road construction, irrigation system, all those things will be done by those autonomous districts. So they will be getting more autonomy, right? And in this autonomous district council, there will be 30 members, and they will be elected for the 5 years. And whatever these plans, policy will be made by these autonomous districts, so that will be sent to the governor's approval. So this will not be like that without any government approval. All these things will be implemented, because even the state legislative assembly will have to take permission, to take assent from the governor to make a bill into the act, right? So that is there. But the thing is, why Ladakh want this? Because if such autonomy will be given, the Ladakh may restrict several kinds of things, that only this much tourists can come into the Ladakh region, only in these months they can come, right? Then there will be some kinds of restriction on the this areas, that in those areas they cannot go. So such kinds of things may be put up by the Ladakh, and therefore they want this kinds of autonomy, right? So that is there. The next news is regional benches of the Supreme Court. Time and again this has been in the news several times. If you see the constitutional provisions, then Article 130 of the Constitution says that the Supreme Court will sit in the Delhi or such other places as the Chief Justice of India, which with the approval of the President may appoint. So this point is very, very important for your prelims point of view. So right now the Supreme Court is there in the Delhi, everyone knows that, but there can be another place also where Supreme Court can function. And who will decide this? Chief Justice of India will decide with the prior approval of the President of India, right? So there has been increasing demand that why don't we make regional branches of the Supreme Court? Because right now what is happening? Even the Kerala people have to move from the Kerala to the Delhi if they have to fight anything in the Supreme Court. Even the Assam, Nagaland, Mizoram, Tripura people, right, means whole northeast people, they will have to travel thousands of kilometers to Delhi to fight any kinds of thing in the Supreme Court, right? So instead of that, if there will be regional branches like in the Bombay, Kolkata, Guwahati, like this Chennai, so what will happen? That people will not have to travel so much larger distance to fight a case in the Supreme Court, and the Delhi branch of the Supreme Court will focus on the constitutional cases only, right? So this is the type of demand which are being there. Several commissions recommendation has been there. For example, the Law Commission recommendation in 2009, they have said that they recommended for the formation of the regional benches of the Supreme Court. Private member bill has been also there. They wanted that 4 regional branches should be there in the Delhi, Mumbai, Chennai and the Kolkata. And even Parliamentary Standing Committee they had also accepted that this regional branches should be opened, right? But there is lots of issue also, because currently there are only 34 judges, right? So even at the one place, even at the Delhi, that is not sufficient. And if there will be more of the regional Supreme Courts, right, more of the regional branches of the Supreme Court, so these judges will have to frequently travel from one place to another place to tackle such cases, right? People will not have to travel, but these judges will have to constantly travel. So that will be a cumbersome process for the judicial personals. So right now it has not been done. Another thing which was in news was this Chandigarh mayor election, in which the Article 142 of the Constitution of India was used by the Supreme Court, right? So what has been in the news issue, that is not important for your prelims point of view, do not go into there. Just basically you should understand that in the mayor election of the Chandigarh, some kind of like fraud happened, right? The officials who was conducting such election, right? So their conduct was such, means their conduct was corrupt in nature, right? So therefore the Supreme Court has given the statement that there is a mockery of democracy, and they ordered the ballot recording, the security camera footage, वगैरह, all these things they had been taken. And the thing is कि the Supreme Court came as a savior of the democracy, and finally what should have been done by the election officers only, the presiding officers only, right? So that was implemented by the Supreme Court later on. So that is there, but how this is possible, that you have to focus. UPSC already had asked questions regarding the Article 142. So Article 142 is once again very important this year also. So Article 142, it provides a special power to the Supreme Court, and it is a discretionary power, and this discretionary power says that it empowers the court to pass a decree or make order necessary for doing complete justice in any case or matter pending before it. So if the Supreme Court feels that at any given point of time complete justice has not been there, then Supreme Court can issue any order, any judgment, any decree, right, to do that complete justice. If any section of the people is means getting exploited, discriminated, or anything such is happening, then Supreme Court can use this special power of Article 142. For example, the Supreme Court previously has used Article 142 when the Visakha guideline came, sexual harassment at the workplace, right, and several other use has been there. For example, the banning of the liquor sale within the 500 meter of the national highway and the state highways, right. So such kinds of things has been there. Regarding the mayor, you said you understand that the mayor is the it is elected by the municipal corporation or the council members, and it serves as the leader of the urban local bodies. But the thing is, in India, at different place, the mayor election and its tenure is different, right. At some place the mayor is there for only for 1 year, at some place mayor is there for the 5 years, at some place the mayor gets the elected indirectly, at some place mayor gets elected directly. So there is no fixed thing, there is no uniformity that on the what basis the mayor will be elected in our country in different municipal corporation. Different municipal corporations has different kinds of rules regulation as per depending upon the states, right. So that is there, you should understand this. The next news is the Supreme Court ruling on the definition of the forest, right. So recently there has been this Supreme Court in an interim order said that the state and the union territories must act according to the definition of the forest as laid down in the landmark Tamil Nadu Gordar Varbanam versus Union of India. So what does this says? So this, according to this, the forest would include any land recorded as the forest in the government records. So if any government records any land as the forest area, so that will be considered as the forest area. And another thing is any land that satisfied the dictionary definition of the forest. So if that is there, so if it is coming under the forest definition, so that will be there, because dense forest, very dense forest, so there are some kinds of definitions regarding that, right. So if that is being fulfilled, so it will be considered as the forest. If you see the forest regarding thing, then there has been constitutional provisions also. Article 48A, very important section for the UPSC Prelims point of view. There has been direct questions from the directive principle of state policy and the fundamental duties. You must remember all the directive principle of state policy as well as what kind of directive principle of state policy it is, whether it is a socialistic, whether it is a Gandhian, whether it is a liberal intellectual, right. So that you have to remember. Plus you also have to remember fundamental duties. Please remember these two sections, because this is very important. So under the Article 48A of the Constitution, it provides that the state shall endeavour to protect and improve the environment and the safeguard the forest and the wildlife of the country, right. Similarly, Article 51G, it says that it shall be the duty of every citizen of India to protect and improve the natural environment, including the forest, lakes, rivers, wildlife. So one thing, if you see the differences, this is for the state and duties is for the citizen. So that is very common thing, but one word is there, natural. There is no such word natural in Article 148A of the Constitution of India, is under the directive principle of state policy. So if you see natural words, definitely this will be there in the fundamental duties. Using this trick you can eliminate the option, right. And for the first time National Forest Policy 1952 had said that minimum 33% of the land area should be forest, right. This fact is also very, very important. In the UPSC prelims any statement may come, right, that for the first time which had said. So for the first time National Forest Policy had said that the 1/3 of all land should be brought under the forest cover, and for the hilly and the mountainous regions it should be 60% of the total land. Another thing which you have to remember here is the reserve forest thing. So in the Indian Forest Act of 1878 itself, means it was a colonial act itself, from there only these three categories was there, that was reserve, protected at the village. Later on through the Indian Forest Act 1927 also such kinds of things, reserved and the forest protected areas of the forest was announced. So I hope this is clear to you. Next thing which was there in the news was criminal case management system or the Sankalan app. Again not very know what does this Sankalan app does, right, because UPSC may ask about the Sankalan and 4 statements may be given, out of that you have to identify one. So the Ministry of Home Affairs has recently inaugurated this digital crime case management system, and it was developed by the National Investigating Agencies, right. And this will be just like a digitalized thing to do have a register of all the criminals related data, right. So that is there. So it will be user friendly and easy to topple. So all these things will be there. So that has been there. What you have to remember is this Sankalan app. So it has been designed to navigate through the new criminal law as a bridge between the old and the new criminal law, and it will work in offline mode as well, equivalent. So very, very important points. In UPSC prelims you may see the question regarding this. And regarding the criminal case management system, what does this do? So it enables the integration, organization and digitization of the data generated during the investigation, providing comprehensive tools to investigation, prosecutors and others. So whatever data will be generated while prosecuting a person, while conducting any kind of inquiry, so all those things data will be in the digitized form and that will be saved. So if anyone, means if the police personnels want to access those data later on, so that can be accessed, right. So this is there, not very, very important, but still you should know. The next news which was there is Rajya Sabha passed bills to include the PBTGs in the ST list. PBTGs are the particularly vulnerable tribal groups, right. Why this particularly vulnerable tribal groups? Because within the tribal population also there are some groups which are more backward, right, and therefore this PBTGs concept is there. So recently this has been news because several new tribes has been added into this PBTGs, some in the Odisha region, some in the Andhra region, right. So that is there. For example, 4 PBTGs group in the Odisha and the 3 in the Andhra has been there, and Tamudia, these kinds of community has been added from the Odisha, and Mukadora community, Konda Reddy community. So these kinds of tribes were added from the Odisha region only, right. Regarding the PBTGs, if you have to know, then PBTGs has been declared on the recommendation of Diwar Commission 1973, because the section of tribal population in our country, so they are very vulnerable, right, they are very backward, they have been living in isolation, right. So several groups has been there within this tribal people only, which is very backward. Backward in the sense what? They are still living in the pre-agriculture level of the technology. They have the low level of the literacy. They have the economic backwardness, and there is declining or the stagnant population, right? So because of this, the PBTGs are being declared. So in 17 states and the union territories, this PBTGs is being declared. It is currently, previously it was 75 in numbers. So now this has increased further, right? And one important fact you have to remember, that there is no PBTGs found in the Punjab and the Haryana region, because tribal people are only not found in the Punjab and the Haryana region as per the census 2011. So from where PBTGs can be found, right? So that is there. Few facts has been there. Diwar Commission recommendation is there. What has been the condition and its numbering. Another news which was in news was the registration of the Birth and the Death Amendment Act 2023. Once again, not much important for the prelims point of view, but some basic things you should remember, means all the births which is happening inside the country, or all the deaths which is happening inside the country, that has to be registered. Then only you will have the knowledge of how much population India has, right? So this registration of Birth and Death Act 1969 has already been there. Under that, the registration of death and birth has been made mandatory, and there was a appointment of the Registrar General of India by the central government. So such provisions has already been there. There were several posts also, Chief Registrar, District Registrar, another Registrar, and the birth certificates can be obtained without the name of the child also. Now this point is important, right? Because maybe at the time of the birth, several people, several parents do keep the name of the child, but several parents, they take time, right? But registration of the birth is very much necessary when the child gets the birth, right? So that is there. So this act has been amended. Now registration of the Birth and the Death Act of 1969 has been amended, and anything which will be amended at this point of time, what will be there? There will be digitization, right? There will be computerization. So that has been there. So database of the death and birth will be collected, it will be made. There will be chief registrars, and the registrars, they will be obligated to share the data of the registered birth and the death to the national database, so that overall how much population is there inside the country, what is the demography of those population, so that can be means that information should be there with the government, because government has to frame policies, programs for whole the country. Chief Registrar shall maintain a similar data at the state level. Electronic certificates has to be issued. Then the child's has to be registered using the Aadhaar of their parents, right? So that is there, and all this database has to be connected with another database like the population register, electoral roll, ration card, etc. And it is the responsibility of the parents, right, means head of those family, to get it registered. And if the child is born in a hospital, in an institution, then it is the responsibility of that institution to get it registered with this database, right? So all this thing was the most important news of March and April 2024. We should be going back now, because we are covering around 15 months of the news, sorry, not 15 months, 1.5 years of the news. So coming back, and now we will be going like in more organized fashion, ठीक है, because this issue will be coming in a manner that issue related to the constitution, issues related to legislature, issue related to center-state relation, issue related to judiciary, issue related to election, then some legislation, then some constitutional, statutory and executive bodies, and then some governance related things. So all these things we have to discuss in this lecture itself, and this is a mere revision. I hope you are getting the essence of this lecture by now. So starting with this, let's see. So basic structure doctrine, Keswanand Bharati case, it has completed its 50 years. So for that reason it was there in the news. The basic structure doctrine, whether it is written in the Constitution of India, it is not written in the Constitution of India. So it has come out with the judicial interpretation in the Keswanand Bharati case 1973. Whether there is any exhaustive list of the basic feature of the Constitution of India, there is no exhaustive list of the basic feature of the Constitution of India. So who decides which is basic feature of the Constitution of India? Supreme Court of India decides time and again that what is will be coming under the basic feature of the Constitution of India, right? There are several constitutional backing. There is no, this basic feature or the basic structure is not written in the Constitution of India anywhere, but articles like the 32, 136, 141, 142, then this article 13, article 32. So using these articles, the Supreme Court decides what is the basic feature of the Constitution of India. You should go before the prelims. Please go through the exhaustive list. Means no, it is not exhaustive, it will keep on changing, it is dynamic list, right? So till now whatever the list has been there for the basic feature of the Constitution of India, please go through that once before prelims, right? For example, the things like the supremacy of the Constitution of India, limited power of the Parliament to amend the Constitution, secular character of the Constitution, parliamentary system, separation of power, federalism, welfare state, harmony and the balance between the fundamental rights and the directive principle of state policy, rule of law, principle of equality, freedom and dignity of the individual, democracy, free and fair election, judicial review, independence of judiciary. So such kinds of things are there inside the basic structure doctrine or the basic feature of the Constitution of India. Even this is not exhaustive, so please go through the original list from any book which you find, right? And why it is called the basic structure doctrine? Because no matter what, how much majority any government gets in the parliament, any party gets in the parliament, how much majority they get, they cannot change the basic structure or the basic feature of the Constitution of India. So these cannot be amended, right? So that is very, very important. The next article is abrogation of Article 370 and the Currency Proclamation of 1949. Whether Article 370 has been deleted from the Constitution of India? No, Article 370 has not been deleted. Some parts of this Article 370 of the Constitution of India has been made null and void. It has been made now, it has been removed, it has been abrogated, right? Altogether Article 370 has not been deleted, right? So this was regarding the Jammu and Kashmir states. Jammu and Kashmir has a special scenario, right? This was the only state in India which has a separate constitution, and there has been constitutional provisions in our Indian constitution like the Article 35A, which was dealing with for the Jammu and Kashmir region only. So such things has now been removed, and Jammu and Kashmir right now along with the Ladakh is acting as a union territory just like any other union territories or just like any other union territory of the country, right. So that is there. So therefore this has been in news, this has been continuously in the news. So Article 370 it granted the special autonomous status of Jammu and Kashmir, that we have discussed, right. Article 335A it was nullified because it gave the J&K legislature the power to define the permanent residence of the state, and J&K Reorganization Act came up in 2019. From there Jammu and Kashmir have been separated and the Ladakh region has been separated, and we have already discussed about the demand of Ladakh region, right. So that is there. If you see, the Ladakh is the largest area wise Lok Sabha constituency. This fact has already been asked in the UPSC Prelims, right. And currently the Ladakh is demanding that they should have at least 2 members in the Lok Sabha. So maybe if that demand is being fulfilled by the government, so maybe that Ladakh will no longer be the largest constituency of the India, right. So that is there. So this Jammu and Kashmir had their separate constitution, but several provisions was there, several items was there which was being handled by the union government itself. For example, defense, foreign affairs, finance and communication. So such things was already there, right. Whether it is constitutional or not, whether the abrogation of Article 370 is constitutional or not. So Supreme Court recently has given the judgment and it has accepted that this abrogation of Article 370 of the Constitution of India, so it is completely constitutional in nature, right. So it has been done using the valid processes, right. So that is the thing. Not any other things I think is more important here. Karan Singh proclamation not much important for the prelims point of view. Parliament is not a mere law making body during the president rule, not much important, right. So that is there. Another thing which was in news was the clemency power of the president and the governor, or the remission power of the president or the governor, or the pardoning power of the president and the governor. So as you can see that the president and the governor has several kinds of pardoning power, right. They can either pardon or remission, respite, reprieve, right, commute. So they can do several kinds of things. In the pardoning, what happens that they completely resolves all kinds of the cases is completely resolved, and even the convict will not be considered as an accused if the person is pardoned, right. Whether it is written in the Constitution of India, yes, Article 72 of the Constitution of India talks about the president's pardoning power, and Article 161 of the Constitution of India it talks about the governor's pardoning power, right. This president, the president pardons mostly for the union laws, and the governor pardon mostly for the state laws, right. There are few differences between the pardoning power of the president and the governors. For example, the president can pardon court martial cases also. Court martial cases is there where there is this army personals are involved, means army, navy, air force. So this kinds of person whenever is involved, if they are getting court martial kind of thing, so that can be pardoned by the president, because he is the head of the defense forces, right. But governor is not the head of the defense forces, or the governor has nothing to do with the defense forces. So governor has no role to play when court martial is being applied, right. So that is there. the president can pardon the death sentences also, right. So that is there. Earlier this provision was there that the governor cannot pardon death sentences, but in last few years the Supreme Court has interpreted now that the governor can pardon this death sentences also, and many times it is in the Supreme Court also, it has been questioned again. So there is not much clarity. We are going by the previous precedents, means earlier the governor could not pardon the death sentences. So what does this mean? This means that the governor cannot absolve any kind of these criminal related things completely for any person, right. But governor can commute the death sentences, means the governor can change the nature of the death sentences to the life imprisonment. So that can be done by the governor. That is completely possible. Earlier also it was possible, right. So that only we are going by. One thing is that whenever the president or the governor, so they are giving any kind of decision, so it is not their only discretion. Actually it is being suggested by the Council of Ministers whether the governor should pardon the case or not. So that is the case, and Article 74, 1 of the Constitution of India is there, which says that the President will act on the aid and advice of the Council of Ministers, and this is why the President has to take the aid and advice of the Council of Ministers while the President is issuing the pardoning, right. So that is there. Few important points you have to remember regarding pardoning, that is it is executive powers independent of the judiciary, means pardoning power. If you look at this, you will feel that this is judicial power, because the judiciary has given a judgment, right. They have provided the death penalty to some person, but this pardoning power, it is not a judicial function of the President, it is an executive function, because whenever the President considered this matter of pardoning, then it takes the matter completely new. It does not care about what has been discussed in the Supreme Court or the High Court, right. So that will not be discussed. It does not care. It may take up the case completely fresh, right. Therefore it is a executive power, and the President does not sit as a court of appeal, means not every time wherever there will be this death penalty will be issued, not every time the person will be moving to the President, right. So that is, it is not a court of appeal. It can be challenged in the court if it is arbitrary, irrational, malified or the discriminatory. That means the President's power to pardon is coming under the judicial review, right. Had it been a discretionary power of the President, it would not have been questioned into the court. But the thing is, it is done on the basis of aid and advice of Council of Ministers by the President. So it is coming under the judicial review, because these political parties, this Council of Ministers may have the ill intention. Their decision may be arbitrary, irrational, malified or the discriminatory in nature. Therefore there is judicial review, right. I hope that is clear to you. Then the Government of the National Capital Territory of the Delhi Act 2023. So recently in 2023 one act has come up in Delhi, and in which there has been a provision to make a new statutory body, that is the NCCSA, National Capital Civil Services Authority, right. Who will be the member of this Civil Services Authority? Chief Minister of Delhi, he will be the chairperson. Principal Home Secretary of the Delhi appointed by the centre, and Chief Secretary of the Delhi appointed by the center, right. So, if you can see, then in this body, National Capital Civil Services Authority, so this has one Chief Minister as a chairperson and two person will be there which will be appointed by the central government, right. And this is what the problem has been there, because this body decides on majority. So, there may be cases that these two person who has been appointed by the center, they go against the chief minister, and in that case chief minister cannot do anything, right. So, that may be the issue. What will be the function of this NCCSA? They will recommend to the Lieutenant Governor of the Delhi regarding the transfer, posting, vigilance and the accidental matters of what? Civil servants. So, whom to transfer, where to transfer. So, such kinds of things will be discussed by this NCSA, means they will be recommending these things. Ultimate authority who will be taking the decision will be the Lieutenant Governor, right. So, NCCSA decide the matter by the majority of the votes and the members present in the voting. So, this is a issue which is being highlighted by the Chief Minister of Delhi continuously, right, because if the two person appointed by the center, so they accept anything, even if the Chief Minister of the Delhi in opposition, that thing will be taken up, right. So, primacy should be given to the Lieutenant Governor, because Lieutenant Governor is the ultimate authority in this case. He can approve or return the recommendation of the NCSA for the reconsideration, and whatever the decision will be taken by the Lieutenant Governor, that will be final, right. And Lieutenant Governor's sole discretionary power may also have, means there may be matter outside the legislative competence of the Delhi Legislative Assembly, but which has been delegated to the Lieutenant Governor, or the matters where he or she is required by the law to act in his discretion or exercise any judicial or the quasi judicial function, right. So, that is also there. Regarding the Delhi, as you know that it is the capital of India, New Delhi is the capital of India, and this State Reorganization Act of 1956, this has made Delhi as the Union Territory. Later on, through the 69th Constitutional Amendment Act of 1991, National Capital Territory of Delhi emerged, and it is there in the Article 239 AA of the Constitution of India. It made the Delhi a UT with a legislature and the Council of Ministers. So, this special provisions has been there. In Delhi, there is a special case that the Delhi cannot make laws on the public order, police and the land. In general, this does not happen, right. These kinds of items go into the state list in the 7th schedule of the Constitution of India. But for Delhi, what is happening? In these matters, the Delhi Legislative Assembly cannot make laws. So, that is a issue for the Delhi, and this is why the Delhi has been demanding for making it a complete state, right. Statehood should be provided to the Delhi. And one thing you should remember, that the L. Balakrishna Committee had recommended the formation of National Capital Territory of Delhi, right. So, that is there. Another thing which was in news was the preventive detention. Many times it has been there in the news. Before we understand preventive detention, let us understand that there are two types of detention. One is punitive detention and another is preventive detention. So, in punitive detention, whenever the crime is being committed, only then the person will be arrested. So, that will be coming under the punitive detention. And in the preventive detention, even if the crime has not been committed, so at that point of time, this prevention can be done. A person can be detained so that the person can be prevented from doing any kind of crime, right. So, there are two kinds of provisions written inside the Article 22 of the Constitution of India. Right. In the starting article, like the Article 22 ka 1, it says that the right to be informed about the reason of the arrest. If any person is being arrested, then that person, why that person has been arrested, that reason has to be stated. Article 22 also says that the right to defend by the legal practitioner of his choice. If a person has been arrested, then the person should have the right to appoint a legal practitioner who can defend that person in the court, and the right of the person to be produced before the magistrate within the 24 hours. So if a person is being arrested, then that person has to be brought to the in front of magistrate within 24 hours, and above the rights does not apply to the preventive detention. Means such kinds of provisions is not there in the with the preventive detention. These are there for the punitive detention only. So what are the differences between the two? The differences are very common, whatever we have read, that is, in normal scenario, in case of punitive detention, what has to be there means whenever there is ordinary law applies, so what has to be there, the reason for the detention must be told to the person, is why that person has been detained. But in case of preventive detention, in general scenario, what happens that during the preventive detention also reason is being stated, but if it is found that it is for the public interest, that reason cannot be stated to the person to whom the detention has been made. So in that case, the reason may not be stated. Right. Another thing was that in the normal scenario, what happens that if the person has been detained, that person has to be brought to the magistrate within 24 hours of that detention. But there is nothing such required in case of preventive detention. A person can be sent in the preventive detention for 3 months, right? And even after the 3 months, if the person has to be detained further, then one advisory board will be there, that will be set up. There will be several judicial members will be there inside that advisory board, and this advisory board will decide whether preventive detention should be extended or not. So that will be the case. Then it must be defended by the legal practitioner of his choice, but in preventive detention, they must be given opportunity to make representation against the detention order, so that thing they get, but the thing is ki not necessarily they will get also. So they cannot vote in the election if they are in the ordinary law detention, if they are in the punitive detention. But in case of preventive detention, as the person has been detained and it is a preventive measures, right? So that person is still not accused of any kind of crime, right? Any kind of crime has not been done by that person. Therefore, that person is allowed for voting also. So in the preventive detention, a person can vote through the postal ballot, and the law can be made by the parliament or the state legislature in case of ordinary detention, and in case of preventive detention also law can be made by the parliament and the state legislature, right? There are several things for which the preventive detention can be made. Whether there is any exhaustive list, no, there is no any exhaustive list, but you can guess that the things like the foreign affairs related, security, public order, maintenance of essential services, so several kinds of things are there for which the preventive detention can be done, right? I hope this is clear to you. Another thing which was in news was the right of personality, right? So what is this? Whichever person is there, they will have the right of personality, means their face, their sound, means their whatever the voice they have, right? So their voice, their face, their physical character, so such kinds of things so cannot be put up for the commercial purpose without the permission of that person, right. So what is they are having? They are having the right of personality. So whatever the personality the person has, what the name, the voice, the signature, the image, so whatever they have, so it is, they have the complete right over there. They will have the right to privacy or the right to property included, right. And such things cannot be used for the commercial purposes. What are the constitutional backing for this? Article 21 of the Constitution of India, which says that the right to life and personal liberty, and Article 300A of the Constitution of India, that is the right to property, right. And recently this case was there in the Delhi High Court, in which a famous Bollywood actor was there who had come up that some person is using his face and his voice, but that should not be used unnecessarily, because that will be unconstitutional in nature. Whether this right to of personality is written explicitly in any statute, any law, so that is not there. It is neither written in any constitution or nor it is written in any statutes or the law. But there are some statutes or the law which indirectly talks about the right to personality, like the Trademark Act 1999 and Copyright Act 1957, right. So कुल मिला के बात ये है that no person or the no institution, no company, no factory, no one, no businessman, small or large, can use this any personality's image for their commercial benefit without the permission of that person, right. So that is there. This part you have to remember. So through the several Supreme Court judgments also such things has been proved, but not much necessary for your prelims point of view. International convention like the Rome Convention, TRIPS Agreement, WIPO Performance and the Phonogram Treaty, so these kinds of things also covers this right to personality. I hope this is clear to you. Another new thing which was in news was the hate speech. Again and again this hate speech is in news continuously. So this hate speech, it has not been defined in any law. It is neither written in the Constitution of India, means neither defined in the Constitution of India, nor there is any definition written in any statute or any law. So that is there. And on how this hate can be propagated, it can be done using the image, cartoons, memes, gestures, symbols, anything, whether online, offline. If any kind of such mischievous things can be done, then that is hate speech, right. Constitution of India, under the Article 19(1)(a) of the Constitution of India, it provides right to freedom of speech and expression. But this right to freedom of speech and expression has some kinds of limitation, and reasonable restrictions has been put in Article 19(2) of the Constitution of India, right. That the reasonable restrictions can be put on the basis of public order, incitement of offence and security of the state. So this hate speech has not been clearly mentioned in the Article 19(2), but this will be coming under these parts. Means if any person is doing any hate speech to disturb this public order, if they are inciting some kind of offences, so that will be the violation of Article 19(2). So on the basis of Article 19(2), there can be reasonable restrictions provided on that person. So that is completely possible. There has been several kinds of acts also which is covering this hate speech kinds of things. For example, recently the Bharatiya Nyaya Sanhita 2023 has been there. So they are included that the creating enmity, spreading hatred, etc. These are punishable in nature. Representation of People's Act 1951 also covers that. If any person is having, if any candidate is doing hate speeches, right, on the basis of religion, on the basis of custom, creeds, caste, so on that basis that person can be disqualified. They will not be able to conduct contest election. Then there are Protection of the Civil Rights Act 1955. It penalizes the incitement to and the encouragement of the untouchability. So if any person is propagating hate speeches against those scheduled caste and scheduled tribes population, means doing some kind of propagating some kind of untouchability thing, so that will be coming under here. Religious Institution Prevention of the Misuse Act 1988, it also prohibits using the religious premises to promote disharmony or the hatred. So even if from the religious places you cannot do hate speeches, right? So that is not possible. Similarly, there has been several kinds of Supreme Court judgments. We do not have to go much detail into this, but still you should see Shreya Singhal case. Supreme Court held that the reasonable restriction under Article 19(2) on the freedom of speech and expression may be imposed only if it incites violence or lead to public disorder. So only in case of some kind of violence has been created, this hate speeches kinds of restrictions can be put on, not without that. So that is there. Next thing which was in news was Place of Worship Act 1991. So why this has been news? Recently you have seen that this Gyanvapi temple was there in the news, because some puja archana has started in the Gyanvapi temple, and the Allahabad High Court has said that some kind of puja archana can be done in some part of this, it is not a temple, it is a mosque. So Gyanvapi mosque, right? So this in the Varanasi it is. So in the Gyanvapi was this puja archana can be done by the Hindus in the mosque in some certain part of that mosque where that platform is being made. So that is there. So does that mean that any place of worship can be converted from one religion to another religion? If the temples can be converted into the this masjids, mosques, or the mosque can be converted into the temples, whether it is possible? It is not possible. Why? Because Places of Worship Act 1991 came, and in this Places of Worship Act 1991, it said it banned the conversion of the places of the worship. Since when? Since 15th of August 1947. Means a place which was there, temple, mosque, gurudwara, church, right, or anything, so that will keep on continuing in exactly same fashion whatever it was there at the time of independence. So this is what this act has to say, right? So this is a positive obligation on the state to maintain the nature of that religious place, just like it was there at the 15th August of 1947. And it does not allow the government to take over the management of any place of the worship. Even the government cannot take up the management of any place of the worship. And any attempt to change the religious character of the place of the worship is a criminal offense. So that person will be getting the punishment on the nature of the criminal offense if the person is trying to convert one place of the worship into the another, right? So that is there. Then you will think that how then this Babri Masjid got converted into the Ram Janmabhoomi temple in Ayodhya? Because this act has been made in 1991, and while making that act, this Babri Masjid issue or the Ram Janmabhoomi issue was already there. So there has been this exception written inside the act. So two exception is written inside the act, that is the Ayodhya dispute site, Ram Janmabhoomi Babri Masjid will be an exception. Another thing is the monuments and the sites covered by the Ancient Monuments and the Archaeological Sites Remains Act 1958, right? So that will be there on the basis of this. So if Gyanvapi mosque has to be converted into the temple, for that this Act, Places of Worship Act 1951 has to be amended first, right? Only then that can be done. Another thing which was in news was the 8th schedule of the Constitution of India. Why? Because the Odisha cabinet has proposed for the inclusion of the Kui language in the 8th schedule of the Constitution of India. 8th schedule of the Constitution of India know that this is regarding the language. Currently there are 22 languages in the 8th schedule of the Constitution of India. Earlier in starting there was only 14 languages in the 8th schedule of the Constitution of India. Later on, through the 21st Constitutional Amendment Act, Sindhi was added. Later on, through the 71st Constitutional Amendment Act, this Konkani, Manipur, Nepali was added, and through the 91st Constitutional Amendment Act, this Maithili, Bodo Dogri, Maithili, Santhali was added. So then 14 plus 15, 14 plus 1 15, 15 plus 3 18, and 18 plus 4 22. It became the 22 language. One few important points you have to remember where UPSC may confuse you and the aspirant may get confused, that this 14 language includes Urdu, Nepali, Kashmiri. So these are included, but many languages are not included till now in the 22 languages, right? So these are like the English, Rajasthani, Haryanvi, Ladakhi. These are not included. English is not included in the 22 languages in the 8th schedule of the Constitution of India, right? So this you should remember. Rajasthani is also not there. And few Braille script, Braille language has also been proposed to add into the 8th schedule of the Constitution of India, means including those 22 languages, right? So what are the benefits which we have if we get the any language in the 8th schedule of the Constitution? So that language, they get support from the government for the language to develop. They get recognition from the Sahitya Academy, and there will be wider book publication or the translation. They can be used in the assembly and the parliamentary debates. They can be used in the all India competitive exams. RBI to include it in the currency notes denomination also. So all these things, all these benefits will be there if any language is included into the 8th schedule of the Constitution of India. Now next thing which was in news was the 9th schedule of the Constitution of India. So this 9th schedule of the Constitution of India, so several state governments want to add their act into the 9th schedule of the Constitution of India. Why? Because with the addition of the 9th schedule of the Constitution of India, if any act is added into the 9th schedule of the Constitution of India, and that has to be done through the constitutional amendment only, so they will get some kind of immunity, right? This 9th schedule of the Constitution of India, actually it came up through the first Constitutional Amendment Act 1951, and the main motive of bringing this 9th schedule of the Constitution of India was to have land reform implemented throughout the country. And therefore what happened, that as the land is a state subject, so several state legislatures have made land reform acts at the various states, and through constitutional amendments those state legislature acts was put into the 9th schedule of the Constitution of India. So this gives immunity from being questioned into the courts, right? So there was no judicial review possible earlier in the implementation of those acts which has been put into the 9th schedule of the Constitution of India. Starting with only 23 laws, currently there are 284 laws which are there in the 9th schedule of the Constitution of India, right? So that is there. It inserted Article 31B of the Constitution of India, this that said that the some kinds of like the land rights can be taken by the states, right? Some kinds of properties can be taken up by the states. So that is there. Earlier there was no judicial review possible, but after the IR Coelho case of 2007, right? In the IR Coelho case 2007, it said that as the basic structure doctrine has came up on the 24th April 1973, the day on which the Keswanand Bharati judgment had come. So therefore, after that, whatever the acts which will be put into the 9th schedule of the Constitution of India, so whether that is violating the basic feature of the Constitution of India or not, whether they are violating the basic structure doctrine or not, so that will be questioned in the courts. So judicial review will be possible, but limited to whether it is violating basic structure doctrine or not, whether it is violating basic feature of the Constitution of India or not. So that is there. Reservation for locals in the private sectors. Several states you must be seeing the news like the Haryana, Madhya Pradesh, Andhra Pradesh, Maharashtra, right? So these kinds of states are there which is putting reservation for locals in private sector jobs, right? So Haryana government has also brought this reservation for the locals in the private sector jobs, and the Haryana governments are reserved 75% of these kinds of jobs only for the locals in private sector jobs. So this has been questioned in the court with that whether it is constitutional or not. The Supreme Court has said that it is unconstitutional in nature as it is violating the fundamental rights Article 15 and the 16 of the Constitution of India, right? So this thing is unconstitutional in nature, but several states has been doing this. Those states act has also been questioned at several point of time, but recently this it was not Supreme Court, Punjab and Haryana High Court was there which has ruled this. That is not going to ask in the UPSC Prelims. You just understand that these are unconstitutional in nature. And what is the logic? Because under the Article 16(3), such kinds of things actually can be done by the Parliament only, but this thing is being done by the state legislature, right? So on that basis, plus it is putting some kind of restriction on the people outside the country on the basis of domicile, right? So this is violating Article 15 also. Article 15 says that there cannot be any kind of discrimination on the basis of race, religion, caste, sex, place of birth, right? And 16 says that there cannot be discrimination in employment on the basis of race, religion, caste, sex, place of birth and the descent. So that is there. The Supreme, this Punjab and Haryana High Court had said it is unconstitutional in nature. Then there is right to silence. See, there is difference, one difference. Right to freedom of speech and expression is there in the Article 19(1)(a) of the Constitution of India, right? And using that rights only, you will get the right to silence, because if a person has right to speak, right to freedom of speech and expression, so the person will have the right to be silent also, right? The person may not want to speak, so in that case the person will choose to be silent. So right to be silent will be coming under that. But this right to silence is different. This right to silence is when any person acts as a witness, right? Any person is accused, right? So in that case, this right to silence is different from the right to freedom of speech and expression, right? This will be coming under the Article 23 of the Constitution of India, which says that no one can be compelled to be witness against himself, means rights against self-incrimination will be there. No person can be compelled to be witness against himself, means forcefully no one will be compelled to accept crime, right. So, that is not possible, but the thing is, this does not exclude that the person will not give some kind of samples, for example, photo, DNA samples, blood samples, right, because if the person has not committed the crime, so that will be proved only later on, but the person will have to give such kinds of samples. After the investigation, after the reports, so it will be proved that the person, the accused, is not guilty, and that will, the person will be let go, right. So, there will be the protection is limited only to the criminal proceedings only. Only in the criminal proceedings only the person will be, the person cannot be forced to act as a witness against himself. So, right is not available to a person being integrated under the Custom Act 1962 or the Foreign Exchange Management Act 1999. So, in these acts, this Article 23 will not be applicable. This is very important. So, right is not available to the person being integrated under the Custom Act 1962 or the Foreign Exchange Management Act 1999, because this will be most of the monetary matters or the economic matters, right. So, that is there. Judicial pronouncement, the Nandini Satpathy case, Supreme Court had said that compelling a person to answer a question within the limits of the police station might result in a violation of Article 23 of the Constitution of India. Right. I hope this is clear to you. Right to silence, there are two kinds of right to silence. In normal scenario, the right to silence will be coming under the right to freedom of speech and expression. But if right to silence when some person is being compelled to being witness against himself, so that cannot be done using the Article 23 of the Constitution of India, which is a fundamental right in itself, right. So, that is there. The next thing which remains in news, because issues related to the reservation is always there. Some sections or other section has been asking for the reservation continuously, right, and the debate for the reservation is non-ending. So, that remains always in the news. So, this affirmative concepts, but this reservation thing, that is what? That is affirmative action only. So, you are just putting some kind of special provisions for some section of the people, so that that person can be uplifted, means whatever the status they are having right now, whatever the discrimination or the exploitation that their person has been facing, so that should be stopped. So, this is affirmative action, right, and a system of reservation which is there inside the India, and Article 16, Article 15 of the Constitution of India, it provides for the reservation, right, EWS reservation, SC/ST reservation, women reservation. So, such kinds of reservation has been written inside the Constitution of India. But one thing you should remember, there is no right to reservation. There is no right to reservation unless and until the state or the parliament brings acts or the policies regarding reservation. Till then it will not be automatically implemented. Not all the constitutional articles are automatically implemented, right. So, a person does not have right to reservation. For example, reservation provisions are there in Article 15, Article 16, and if the government want that they will not be providing reservation to anyone from now onwards, that can be completely done, because right to reservation is not there. It is not, does not come under the fundamental right. So, that is there. Through the Indira Sawhney judgment, reservation quota was fixed at the 50% of the OBC, scheduled caste and scheduled tribes in both employment and the reserve and the education, both is there. So, that quota has already been breached now, because 10% EWS quota has been given through the 103rd Constitutional Amendment Act for the economically weaker section within the general category. It was challenged in the Supreme Court. Supreme Court has accepted that this is completely constitutional in nature. So EWS reservation is completely constitutional in nature. So that has been accepted by the Supreme Court. So I hope you have understood this affirmative action. Another thing which was in news was the Article 355 of the Constitution of India. This article itself is very, very important. This article says that it is the duty of the center to protect every state from the external aggression and the internal disturbance. So the center will not let any kind of external aggression or the internal disturbance happening in the country or in the state, right? So that is there, but at the basis of what? It will ensure that the state government act as per the constitution. So only if the state government is acting on the as per the Constitution of India, so this will be ensured. And if the state government is not acting as per the Constitution of India, then Article 365 will be implemented, and using that Article 356 can be implemented, right? That is President's rule can be applied. This Article 355 is very important because on the basis of this, Armed Forces Special Power Act has been applied, and which has got a constitutional basis, right? Constitutional backing. Not Armed Forces Special Power Act is not written inside the Constitution of India. It is a statute, it is a law, but that comes through the Article 355 of the Constitution of India, right? And it also proves have the emphasis on the importance of the state security and the integrity. So overall, this will be the duty of the center to have a secure environment throughout the country as well as in the state. So that will be there. Next thing which was in news was the financial devolution. Financial devolution, all of you know that on the basis of the recommendation of the Finance Commission of India, Finance Commission is formed under the Article 280 of the Constitution of India. So on the basis of that recommendation, this finances is being allocated to the states and the union territories, right? For example, for 15th Finance Commission has recommended for giving the 41% of the amount to the states, 1% to the newly formed Jammu and Kashmir, and the rest 58% to the center, right? So that is there. Not much important. Recently the 16th Finance Commission has been appointed for the 5 years time period, and that has been done by the it will be chaired by the Arvind Pangaria. Obviously 15th Finance Commission is being appointed by the President of India. So that is there. Article 371, and there has been a special provisions for the states. When India got independent, right? So after that, several areas had different things, different types of pattern, right? Some were very backward, some needed special attention. So this special provisions has been made under the Article 371 of the Constitution of India, and several states has been added, right? If you see, then Article 371 A, B, C, D, E, F, G, H, I, J till here it is there, and states like the Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Sikkim, Mizoram, Arunachal Pradesh, Goa, Karnataka, all these things has been added. Whether there is any uniformity in these kinds of states, whether whatever is written for the Maharashtra and Gujarat in the Article 371, same thing has been written in the Article 371 in the Nagaland, that is not there. Different states has different kinds of demands, right? Different kinds of scenarios, and to fulfill that demand and to fulfill that scenario, these kinds of things has been brought. So there is no uniformity in this. You should just remember that these states had got some kind of special provisions. They will be having some kind of autonomy, some kind of the social political kinds of things. So that will be provided to this special category states, right? Now coming to the legislature functioning and the parliament and the state legislature and the local government. Now no confidence motion. Last year no confidence motion was in news because in the Lok Sabha no confidence motion was applied. Can no confidence motion be applied in the Rajya Sabha? No. No confidence cannot be applied in the Rajya Sabha. Why? Because government forms from the Lok Sabha. Right. Council of Ministers are directly responsible to the Lok Sabha only, not to the Rajya Sabha. Right. So that is there. And it has the constitutional backing through the Article 75 ka 3, that is Council of Ministers are the collectively responsible to the Lok Sabha. Similarly, Article 164 ka 2 says that the State Council of Ministers shall be collectively responsible to the State Legislative Assembly. And Rule 198 of the Rule of Procedure and Conduct of Business in Lok Sabha provides a provision regarding the motion of no confidence is there. Right. So what are the conditions for which this no confidence motion can be applied? Because this no confidence motion, it is a censure on the government. If the no confidence motion gets passed, the Prime Minister and the Council of Ministers will have to resign. Right. But in normal scenario, the no confidence motion cannot be passed, because if the government or if the party which has formed the government, that will be in majority, then there will not be the case that no confidence motion can be passed. Right. So what are the conditions? There should be a minimum 50 member of parliaments who should give that this no confidence motion has to be admitted and to be discussed in the House. It can be moved only in the Lok Sabha or the Legislative Assembly. Right. And the Speaker decides whether the motion is in order or not. So it will be the power of the Speaker to decide whether to accept this no confidence motion or not. And if the pass, then Prime Minister and the Council of Ministers have to resign. Right. Whether there is any ground on the basis of which the no confidence motion can be applied, there is no need to give any ground. There is no need to give any reason for which the no confidence motion has to be based. Right. Whether for the same thing, the no confidence motion can be put up again in the same session, that cannot be done. Within one session, if anything has been discussed in that session, so for that purpose, the no confidence motion cannot be applied. Right. So these things we have to understand. The next thing is that was in news was the parliamentary privileges of the lawmaker. We had talked about this privilege, Article 105 of the Constitution of India and Article 194 of the Constitution of India. It talks about the privileges of the member of parliament as well as the member of a state legislative assembly. So why do they have these parliamentary privileges? So that they may function properly. Right. So that they will enjoy the freedom of speech and expression in the House. Right. They may enjoy to publish anything in the House. They may discuss anything. Right. They will have assembly. Right. So that is there. But there are some limitations also. The limitations are there under Article 118 and Article 121 of the Constitution of India. That means the freedom of speech is subject to the rules and procedure of the Parliament as stated in the Article 118. So using the Article 118 of the Constitution of India, the House may frame the rules and regulation, and each member of that House will have to follow that rules and regulation. So that will be there. Through the Article 122 or 21 of the Constitution of India, the member of the Parliament cannot discuss the conduct of judges or the judiciary in the House unless and until it is a substantive motion going on for the removal of any judges of the Supreme Court or the High Court in the judiciary, so in the Parliament. Right. So that is there. One more thing is that the these privileges, these are not codified. There is not an exhaustive list that what will be there inside the privileges and what will not be there, right. So, that is a very problematic thing. Whether judicial review is possible? Yes, judicial review is possible because privileges are not absolute and subject to restriction imposed by the law and the constitution. So, the judiciary will check, means whatever this the person has enjoyed the privilege, so that should have been enjoyed or not, right. What will not come under the parliamentary privileges? Like the right to pass legislation without the president's approval. Each and every bill which will become act, that has to be passed by the president first. In no case without the passing of the president or without the assent of the president, a bill will become a act. So, that is not possible. Right to override the judicial decisions is not possible, right. Means the contempt of court cannot be done. So, that is there. So, such kinds of provisions are there, freedom from the arrest in the criminal cases. These parliamentary privileges will be there for the civil cases as well as for the criminal cases. In the criminal cases, there will be complete, they cannot be like the arrested, sorry, in the civil cases they cannot be, the trial cannot go on while the session is there, plus 40 days before the session, 40 days after the session, that cannot happen. In the criminal cases for the member of parliament, criminal cases can be applied if the person has committed any kind of crime, so that person can be arrested also, right. So, that is there, immunity from the arrest in the civil cases during the session of the parliament, even 40 days before the session and 40 days after the session, that is also there. How anything will be decided if the breach of privilege has been there or not? For that there is privilege committee. The privilege committee is there in the Lok Sabha as well as in the Raj Sabha. So, privilege committee of the Lok Sabha has 15 member, privilege committee of the Raj Sabha has 10 member. So, this committee actually discuss whether anything has any person, any member of parliament has breached the privileges or not, right. So, that is there. Another thing which was in use are the expulsion of the lawmaker or the suspension of the member of parliament, right. So, suspension of the member of parliament, if you see suspension, expulsion, disqualification, all these are different, right. Disqualification happens when the person has not followed as per the Constitution of India, because there are certain provisions in the Constitution of India written which has to be followed to become a member of parliament. If that is not being followed, so the person will be disqualified. For example, a person has to be the citizen of India to become a member of parliament. So, a person has lost the citizen of India, so in that case the person will be disqualified. Similarly, there are several provisions in the Representation of People's Act 1951. On the basis of there will be disqualification. For example, if a person is involved in the corrupt practices, so that person may be disqualified. Plus, there are another form of disqualification, that is through the anti-defection law. So, any person has defected, right, so that person will be disqualified. So, that is there. Suspension is there for the temporary time period only. At max the suspension can be there for one complete session, not more than that, right. Expulsion is different. Expulsion will happen when, as per the rules and regulation, rules of procedure of the member of parliament, means rules of procedure of the Lok Sabha as well as the Raj Sabha, right. So, both this they will have some kind of expulsion. For example, if some motion is brought to expel any person, any member of parliament, either in the Lok Sabha or the Raj Sabha, So if that motion gets passed, that person can be expelled. So that happens. Article 105 of the Constitution of India deals with the power and privilege and immunity of the Parliament that we have discussed. So if any person can be expelled if it has breached the privileges, contempt of the House has been done, means there has to be some decorum which has to be kept inside the Lok Sabha as well as the Rajya Sabha. If the person is breaching that decorum, if the person is violating that decorum or obstructing that decorum, then in that case contempt of House will be seen, and if the person has done the contempt of the House, the person can be expelled. A simple majority needed to pass a motion for the expulsion of in each House. So using the simple majority, a motion will be brought, and using the simple majority, that motion will be passed for the expulsion of any member of Parliament. Right. So that is there. Then there is also a ethics committee. Ethics committee is there for the Lok Sabha as well as the Rajya Sabha. Right. Now this ethics committee decides, means whatever the conduct has been there for the member of Parliament, whether that is unethical or not, whether that is ethical or whether that is unethical. So that for that reason, ethics committee will be there. Ethics committee will be recommending something. On the basis of that recommendation, some motion can be brought inside the Parliament and a person can be expelled from the House. For example, cash for query was there. Right. Recently cash for query happened in the Lok Sabha, for which one Trinamool Congress member has been expelled from the Lok Sabha. So that is there, and that had happened through the reports of ethics committee in Lok Sabha. Right. So that is important. Not much I see is more important here. So let's skip these kinds of facts. Duration of suspension is important. Suspension can be a maximum remainder of the session. Suspension is temporary and for the ongoing session only. Right. So like this point is also important. The Constitution under Article 101 lists down the ground for the vacation of the seats by the member of Parliament. So if a person, this includes the voluntary resignation, disqualification, the continuous absence of a House from the 60 sittings. So a person, if they are absent from the House for 60 sitting, that person can be expelled from the House. Expulsion word is not mentioned in the Constitution. Actually, disqualification word is mentioned in the Constitution of India. Right. There is, now this point is important. There is difference between the expulsion and the disqualification. The Constitution provides for both. Constitution provides means not specifically provides for the expulsion, but the word is not there. Disqualification word is there. Disqualification में होगा if a member of Parliament is disqualified, then that member of Parliament means that member cannot contest election further. But if expulsion happens, then the person can contest election further. For example, this Trinamool Congress member who got expelled few years back, in last year only. So they are again conducting in 2024 Lok Sabha election. Right. So that is there. In the Constitution, the disqualification, the parameter for the disqualification is written, that is holding office of profit, being of unsound mind, being insolvent, or there is invalid citizenship. So in that case there will be disqualification. The next topic is anti-defection law. Anti-defection law, it is written inside the 10th schedule of the Constitution of India. Right. So this, I know that you must be knowing this. There will be three kinds of provisions. if a person is from any political party, and if that person changes the political party, there will be cases of defection, and anti-defection law can be applied. The person can be disqualified. If a nominated MP joins any party after the 6th month, then that person will also be disqualified. And if a party disobeys the whip of that political party, then there will be defection also, and anti-defection law will be applied. One important point is that merger is allowed. For example, if a political party has 150 members, so if 150 members is there, out of that 100 members have decided to form a either new political party or to have a new, to go to the different political party and join that. So that can be completely done. So 2/3 merger is allowed, and this anti-defection law, if anything is being applied, that will be coming under the judicial review also, right. So that is there. One important thing is that the who decides this anti-defection, whether any person has defected or not, who decides this? The chairman or the speaker. In case of Rajya Sabha, the chairman, and in case of Lok Sabha, it is a speaker who decides the case. But other form of disqualification, for example, on the basis of violation of the constitution, constitutional provisions, or on the violation of the Representation of People's Act 1951, who decides? President decides, right. So that is there. The next thing which was in news was the ordinance making power of the president and the governor, right. So what does this mean? Whether it is written in the Constitution of India? Yes, under Article 123 for president and Article 213 for governor. When these ordinances can be issued? The ordinances can be issued when either house is not in the session. When both house is not in the session plus one of the house is not in the session, in that case ordinances can be issued by the president or the governor. Or with whatever the ordinance has been issued, that has to be passed within the 6 weeks of coming back into the session by the both houses. So that is there. And at max in a year, and in a year there has to be 2 sessions, minimum 2 sessions, right. So at max the maximum differences between the 2 sessions, maximum gap between the 2 sessions can be 6 months. So ordinances without passing can exist for 6 months plus 6 weeks. So that is the maximum life of an ordinance. Ordinance cannot be used to amend the Constitution of India, and ordinance has to be issued only on those parameters or the things on which the parliament can make law in case of president, and on which the state legislative assembly can make law in case of the governor. For example, the parliament cannot make a law which violates the basic structure of the Constitution of India or the basic feature of the Constitution of India, right. So ordinances cannot be issued in that matter also. So that is there. Not more thing is important here. The next thing is immunity for the president. Under Article 361 of the Constitution of India, there has been a immunity written for the President of India. So immunity from the legal proceedings during the term of official of the office of the official act. A president cannot be sued or prosecuted in any court for any act done under the official duties. So if whenever the president works or does their official duties, for that reason the person cannot be sued or prosecuted in any courts, right. Immunity is not absolute and does not cover the official or unconstitutional act. So that is there. The Indian president is not answerable to any court of law for the official duties. So that is there. Indian president cannot be arrested right? He is the first citizen of India. Imagine if the person gets arrested, what kind of signal will go throughout the world. So that is not possible. So immune from there will be effective immunity from the criminal proceedings during the term of the office. However, after the term ends, then criminal proceedings can be done, and civil proceedings can be done with respect to his personal act by giving notice of at least 2 months. So this is what written in the Article 361 of the Constitution of India. Then rules for the Parliament visitors. So this was in the news recently because few person has breached the security of the Parliament and they went into the Lok Sabha, right? They jumped into the Lok Sabha proceeding itself, right? So that has been there. So what are the provisions of this? We will not go into the much details of how this security breach happened, but we will be looking up the rules and procedure of the conduct of business in the Lok Sabha. Like Rule 386 of the, it says that the speaker decides who can visit the public gallery and when. So you must have seen that in the Lok Sabha, at the ground level, right, every member of parliament sits at the upper level, many person is sitting. So they are called, they are visitors. So the speaker decides who can visit the public gallery and when. Rule 387 says that the speaker can also ask to visitor to leave if needed, because while conducting the sacred session, this can be done by the speaker. They have all the power. And MP can only get the visitor pass for the people they know. So only the member of parliament of that house, they will be giving some kind of visitor pass to some person, right? And only that person who has got that visitor pass, that will be visiting the parliament, right? So that all these things are there, means overall you should understand that these are written in the rule of procedure. It is not written inside the Constitution of India, right? Each house has the rule of procedure. So that is there. Another thing which was in news was the secretariat of the parliament. So without secretariat, it is impossible to work. Who will do this file thing? Who will type all those bills, right? So who will pass on these bills to the member of parliaments? So there are staffs needed to run the parliament, right? And therefore this secretariat of the parliament is very much required, right? Whether there is any constitutional provisions regarding the secretariat staff? Yes, there is. A student gets confused here. They do not remember this. Article 98 of the Constitution of India, it says that each house of the parliament have a separate secretariat staff. Rajya Sabha will have separate secretariat staff. Lok Sabha will have separate secretariat staff. Parliaments control the recruitment and the work benefit of its staff and has not been made a law for it yet. Article 187 makes similar provisions for the secretariat of the state legislature, right? So such things are there, means there is a provision of secretariat in both the houses, and both houses will have a separate secretariat, right? And obviously several rules and regulations which will be made inside the house for that secretariat. The presiding officer will have lots of say in that. In case of Lok Sabha, there will be the speaker. In case of the Rajya Sabha, there will be the chairman, right? So that is there. Then the next thing which was in news was the 30th anniversary of the 73rd and the 74th constitutional amendment of the Indian Constitution. ठीक है? 30th amendment of 73rd and 74th Constitutional Amendment Act. 73rd and 74th Constitutional Amendment Act, as you know, that this has brought the Panchayati Raj system as well as the urban local governance. So through the 73rd there has been the Panchayati Raj system, and through the 74th there has been the urban local governance. So there is provisions of State Finance Commission, that is written. There is provision of State Election Commission, that is written inside the Constitution of India, right. There is the provision of reservation of seats for the scheduled caste, scheduled tribes and women section. The reservation of seats for the scheduled caste and scheduled tribes will be on the basis of proportion of population, where the reservation of the seats for the scheduled women will be 1/3, minimum 1/3, minimum 1/3 seats will be reserved, right. Several articles has been there from Article 243 to Article 243. This Panchayati Raj provisions is there under Article 190 means 73rd of the Constitution of India. 11th schedule has this provisions regarding 73rd Constitutional Amendment Act. 12th schedule has the provisions regarding what? 74th Constitutional Amendment Act. Different parts has been added. 73rd has been added in the Part 9 and 74th has been added in the Part 9A. In the 11th schedule there are 29 items, in the 12th schedule there are 18 functional items. So I hope all these things are clear to you. There is not much to remember here, right. You must have read this government schemes and all, like the Swamitva scheme. Swamitva scheme is to provide the records of the rights to village owners, right, and issuance of the property cards to the property owners. Overall mapping will be there of all the village lands and who are the owner of that village, so that records will be kept and that will be given as certificates, right. Swamitva certificate will be given. So Swamitva scheme is there. Other schemes are like old ones only, so you must be knowing Rashtriya Gram Swaraj Abhiyan and Sansad Adarsh Gram Yojana. So I think you must be knowing all these things, not much to teach here. The next thing is, which was in news, was the Capacity Building Commission. Not much important, just remember that the Ministry of Housing and Urban Affairs has collaborated with the Capacity Building Commission to hold a national workshop on the capacity building on the urban local bodies. Not much important. The next thing is Panchayat extension to the Scheduled Areas Act 1996. Many times this is in the news. Why? Because it is poor implementation of Panchayat extension to the Scheduled Area Act. Why came up this Panchayat extension to the Scheduled Area Act? So because when this Panchayati Raj system came up, right, at that point of time, wherever there was scheduled area, under Schedule 5 of the Constitution of India. So in whichever states it was there, 10 states are there. So in those area it was said that the Panchayati Raj will not be implemented. Later on, the committee set up, this Dilip Singh Bhuria committee, and this Dilip Singh Bhuria committee has recommended that the panchayat should be extended to these scheduled 5 areas also. And then this act, just after the 4 years, this Panchayat extension to the Scheduled Areas Act 1996 came. And Ministry of Panchayati Raj is the nodal agency of this ministry. So that is there. Under this Panchayat extension to the Scheduled Area Act, this local level power has been given. Most power has been given to the Gram Sabha. The Gram Sabha will have the power to form this identification of the developmental projects, preparation of the developmental plans, right. Gram Sabha will be consulted before any developmental plans are to be undertaken in the scheduled area. Gram Sabha to preserve the indigenous tradition, belief and the culture. Gram Sabha to resolve the local disputes. Gram Sabha they will help in the administration and must be consulted. Gram Sabha will hold the right to control distillation, prohibition and the manufacture of the intoxication and the liquors. Many times the UPSC has asked question from this part. So this is very, very important because the Gram Sabha is getting so much attention here. And this Panchayat extension to Scheduled Area Act is called as the constitution within the constitution. Right. So that is there. Next thing which was there in news was the panel of vice chairperson, right, in a house, in Lok Sabha as well as in the Raj Sabha, as well as in the state legislative assembly. There is a chairperson, there is a vice chairperson, and imagine both chairman and the vice chairperson are like the absent. Who will preside that session? So for that, a panel of chairperson is appointed by the chairperson of that house. So whenever chairperson and the vice chairperson are absent, then anyone from that panel can preside over that session, right? So that is the fine. Now one thing you should remember, if chairperson and the vice chairperson, they are the post is vacant, no one is there on that post, in that case the panel of chairperson will be invalid. Why? Because the chairperson appoints the panel of chairperson. If the chairperson post is vacant, the vice chairperson post is vacant, then the panel of chairperson does not have any significance. Who will preside over the session at that point of time? Whoever is being told by the president. So the president will decide that in case of vacant seats of the chairperson and the vice chairperson, so president will decide who will preside over the session. I hope this is clear to you, and this happens in both the house. Then the special session of the parliament. Parliament, as you know that there are three sessions: budget session, monsoon session and the winter session. Beyond this session, if any special session has to be conducted, so that gets conducted by the President of India. It is only the President of India who will convene this kinds of session, right? So President of India is among the member of Parliament, right? But the Cabinet Committee on the Parliamentary Affairs determines the date and duration of the parliamentary session. So that session will be, this date and duration will be decided by the Parliamentary Cabinet Committee on the Parliamentary Affairs. Then this will be corresponded to the President of India, and the President of India will be summoning the session, because summon of the session can only be done by the President of the India. Prorogue of the session can only be done by the President of India. Adjournment and the adjournment side die can be done by the presiding officers in both the houses, right? So that is there. Then Rule 176 and Rule 267 of the Council of States, not much important. Rule 176 says that the raises a specific issue for the brief discussion letting up of the 2.5 years, and Rule 267 it empowers the Rajya Sabha MP with a chairman approval to temporarily halt the planned agenda and discuss another topics. So like these kinds of normal things is there, not much important for the prelims point of view. Another concept is there, that is subordinate legislation or the delegated legislation, right? So if anything has been said to be done by the A, and A does not have time to do this, right? And B will be the subordinate to A, and if the A tells to the B, please do this work, A had to do, but it will allocate the B to do this, right? So what is happening? The subordinate of B is doing the work of A. So what kind of thing it is? Subordinate legislation. Legislation you already know, right? So subordinate legislation is the legislation made by an authority subordinate to the legislature. For example, this legislature, they have to make the rules, regulation, laws, whatever etc., right? But many times the legislature does not have the time. Therefore, it gives this power to the executives, right? So overall law will be made, means overall act will be made by the legislature, but executives will make the exhaustive list of rules and regulation on the basis of which that act will be implemented, right? So That is what? That is subordinate legislation. I hope that is clear to you. Another thing which was in news was the cooperative federalism. Cooperative federalism means federalism, you already know, and cooperation among the federation, that is cooperation among the center and the states. So that is cooperative federalism. There are different ways through which the cooperative federalism can be ensured. For example, the 7th schedule of the Constitution of India, it talks about the congruent list. So center as well as the state both will make laws for that. Union, on the union list, the union will be making law. On the state list, the state will be making law, right? So such provisions will be there. So that is there. All India services, as you know, it is being appointed by the Union Public Service Commission, UPSC, and all India services, that is IAS, IPS and the Indian Forest Services, they will be allocated state cadres, right? And in that cadre, though they are a central government, they will be allocated states, and in the state they will have to go and work for that. So that will be a cooperative federalism things can be ensured. Several constitutional articles are there. For example, Article 262 of the Constitution of India. Similarly, there are integrated judiciary, Supreme means District Court, High Court, Supreme Court. So that pattern is there throughout the country. So there, that is there. Article 263 of the Constitution of India, it talks about the Interstate Council. Article 262 of the Constitution of India, it talks about the interstate water disputes regarding things, and then GST Council is there, Article 279A of the Constitution of India. Then like the Finance Commission is there, Article 280 of the Constitution of India. Zonal councils are there, right, which is a statutory provisions. So through this you can understand that the cooperation between the center and the states can be made. So whenever you have to write an answer in the mains, please you can mention these points for the cooperative federalism, or at least you can think on these lines that how cooperative federalism can be ensured. And if at all any question being asked that which of the following ensures cooperative federalism, all India services, Article 262, Article 263, so all those things will be your answer. Then the methods to resolve the disputes among the states. We had seen Article 131 in this session only, that Article 131 of the Constitution of India, it provides exclusive and the original jurisdiction to the Supreme Court of India, that if any two or more states, or if two or more states and the center are involved in any kind of disputes, then that disputes can directly reach to the Supreme Court, and Supreme Court will handle only that kind of disputes. So if any disputes happens between the center and the states, then it can be solved at the various platforms like the Interstate Council, which is being set up through the Article 263 of the Constitution of India. It can be done using the Zonal Council, which has been set up, means 4 zonal councils has been set up in the State Reorganization Act 1956. Sorry, 5 zonal council has been set up through the State Reorganization Act 1956, and 1 zonal council, that was the Northeastern Zonal Council, was set up through the Northeastern Zonal Council 1971. So that is there. Through this zonal council, who is the chairman of this zonal councils? So Union Home Minister are the chairman. Who was the vice chairman of this this zonal council? So whichever zone it will function. So the chief minister of those states of which this zonal council are there, on the basis of rotation, they will be acting as a vice chairman of the zonal council for 1 year, right. Then other members are also there for have a better coordination between the center and the states. Another thing you can see that the interstate water disputes, water is a state subject, and it has been listed under the article entry 17 of the Constitution of India. Article 262, it provides that there will be adjudication of the water disputes, right. And for solving the water related dispute, the center has brought several kinds of acts. For example, Interstate Water Disputes Act 1956, River Water Disputes Act 1956. So such kinds of acts will be helpful in solving the Interwater Disputes Act. You must have read in the geography and other parts like the Godavari Water Dispute Tribunal, Kaveri Water Dispute Tribunal, Mahadevi Water Dispute Tribunal, Mahadevi Water Dispute Tribunal. So there are several kinds of dispute tribunals which has been set up for the settling of the disputes between the various states. Then the role of governor. Governor, it is a constitutional body. One very important point is that the governor is appointed by the President of India. It is not indirectly elected like the President of India. And at the center there is a Vice President, but at the states there is no Vice Governor, right. So that is their governors. Regarding all these things you must be knowing. I know governor everyone knows. So like okay. Qualification, not much is there, that is he should be the citizen of India, he should be having at least 35 years of the age, right, and he will have the dual capacity, that is the federal system of the Indian Party. He will have the constitutional head of the state as well as the agent of the center in the states. So that is there. Pardoning power of the governor we have already discussed, and whenever a bill comes to the governor has three options. Either it can give the assent to the bill, either it can send back the big bill for the reconsideration for the council, means legislative assembly, or it can take that bill into the pocket. So, but in no case the governor can reject the bill completely. Right. So there will not be absolute veto which will be enjoyed by the governor. Recently Supreme Court judgment has said this, right. So governor will enjoy pocket veto as well as the suspensive veto, because it is sending the bill for the reconsideration of the legislative assembly, but it cannot enjoy the like what this absolute veto. It will have to mandatorily send the bill back to the legislature. Why it is happening? Because governor is a appointed body and the legislative assembly, it is a directly elected body by the people of the state, right. So that is there. So similarly the governor will also have the immunity, just like the Article 361 is there for the president. The governor will have the immunity. One very important point is that regarding the governor there is a word discretion written inside the Constitution of India, but regarding president discretion word is not written inside the Constitution of India. So governor will have the discretionary power on several things. For example, under Article 200 of the Constitution of India, the governor can reserve a bill for the consideration of the president, right. Governor under the Article 356 of the Constitution of India can recommend to implement the president's rule in the state to the president, right. So all those things are there, that will be coming under the discretionary power of the governor. Situational discretionary are there, it is similar to the president only, means just like the president has the situational discretionary power when there is no obvious successor of any, means there is no obvious person who can become the prime minister or the party, if any hung assembly is there. So in that case the prime minister will be chosen by the president, and that prime minister will have to prove the majority in the floor of the house. So similar thing is there for the chief minister also. So there are some situational discretionary power also. I know that you must be knowing all these things. A special category status is there. How it is being issued? It is being issued on the basis of Gargill formula. Like there should be a hilly terrain, low population density or the sizable share of the tribal population, strategic location and the border with the neighboring countries, economic and infrastructure backwardness, non-viable nature of the state finances should be there. There are 11 states who is being given the special category status. 8 sisters in the northeastern states, along with that Uttarakhand, Himachal Pradesh and the Telangana. So they have been given special category states. Several states like the Odisha, Bihar has been demanding for the special category states since several decades, but they have not been provided, and recently the 14th Finance Commission has recommended that there is no need to provide a special category status further to any new states. So there are more likely that no more special category status can be provided, right. Few benefits which special category status states gets, that there 90% of the funds are centrally sponsored in case of the special category status, but in case of normal states there are only 75% funds being allocated. Judiciary, regarding the judicial appointment, the Supreme Court heard a contempt using this. The judiciary, you know that President of India appoints all the judicial members, that is the judges, the Supreme Court judges as well as the High Court judges, that will be appointed by the President of India, right. So on the basis of recommendation of the collegium system, in the collegium system for the Supreme Court judges there will be Chief Justice of India plus 4 senior most judges. For the High Court there will be Chief Justice of India plus 2 senior most judges. So on the basis of that recommendation, Supreme Court judges will be formed. A new thing was trying to be brought, that was the new National Judicial Appointment Commission, but that was brought in the 2015, but later on the Supreme Court has made it unconstitutional in nature. So this is what is there in the judicial appointments only. One important point you have to remember here is the government's role is limited to getting an inquiry conducted by the Intelligence Bureau if the lawyer is to be elevated in this. So what are the government role in this scenario? The Intelligence Bureau will be conducting the intelligence related thing, that if any person is right person to be elected as a Supreme Court judge or the High Court judge or not, right. All India Judicial Services has to be brought to have it is proposed to create a central services for recruiting the judges at the level of the additional district judges and the district judges of the it will be similar to the UPSC civil services exam. So not much important, because these things has been proposed in several decades, but still these things has not been implemented yet. What is the present status of recruitment of the judges in the lower basis? So Article 233 and 234 of the Constitution of India deals with the appointment of the district judges and places the domain in the state. So at the state level these district judges are being appointed, right. Then the legal aid of India. So this was in news as well. Legal aid service, there is a Legal Service Authority Act 1987 of the Constitution of India, Legal Service Authority Act 1987. Under this there is NALSA, National Legal Service Authority Act, State Legal Service Authority Act, SALSA is there. So several kinds of, and also DLSA is there, like the district level service authority is there. So all these things is there. Why has been they brought this? Because many poor sections are there inside the country who are not able to have a justice, and right to justice is there under the fundamental right. Right. So that is there. Who are eligible for this? Please have a read on this, because UPSC has already asked a question regarding this. Constitutional backing is there, Article 39A of the Constitution of India, which is the directive principle of a state policy, and using that directive principle of a state policy, it is the responsibility of the state to provide the free legal aid to the poor. So on the basis of this only, this legal service aid is being provided. Please read this, that who are eligible for this. One important point you have to remember here is Lok Adalat. So Lok Adalat is also been formed in the under the Legal Service Authority Act 1987 only, right. So National Lok Adalat, State Legal Service Authority, High Court level, so several at different levels जो है Lok Adalats are being organized. Mobile Lok Adalats are also being organized. This point is very important. The nature of the cases, that is civil cases, matrimonial disputes, land disputes, partition of the property disputes, labor dispute, etc. are the non-compoundable criminal cases are being tackled by the Lok Adalat, right. Then, and this is also parties to the disputes can directly interact with the judges through the counsel, and there is no court fee in the Lok Adalat. So these 3 points are very important regarding the Lok Adalat. Rest everything is normal only. Article 142 we have already discussed. Article 142 is regarding the giving complete justice to the people, right. It is the very special power provided to the Supreme Court of India. Then advocate on records. Advocate on records, see in the Supreme Court, every case has to be filed in a proper manner, right. So there is formatting for that. So only if there will be advocates dedicated for that, they will be knowing this, right. And therefore in the Supreme Court that advocate of record concept is there. Means they will be, it only advocate on records will be eligible, or only advocates on records will be will have the permission to draft a case in the Supreme Court, so that the time of Supreme Court judges should be saved. So that provision is there. It is not a constitutional provision, but it is written inside the Supreme Court rules 2013, right. Only AOR is entitled to file any matter or the document before the Supreme Court. So that is there. And Supreme Court in the exercise of the rule making power under Article 145 made a provision for the AOR system. So this AOR system, it is not written in the Constitution of India, but under the Article 145 of the Constitution of India, the Supreme Court make rules and regulations. So based on that, the Supreme Court has made these rules. Then Chief Election Commissioner and the other Election Commissioner Act 2023. So this act has done several good provisions are there inside this act. That is, there will be a selection committee. The President will be appointing the Chief Election Commissioner and the Election Commissioner on the recommendation of a selection committee. The selection committee will have Prime Minister as the chairperson, leader of opposition or the leader of largest opposition party in the Lok Sabha, and the Union Cabinet Minister to be nominated by the Prime Minister, right. So that will be there. There will be a search committee. Search committee, it will be headed by the Ministry of Law and Justice, who shall prepare a panel for the consideration of the selection committee. So that is there. Salary will be equivalent to the cabinet secretary. Earlier the salary used to be equivalent to the district judge, Supreme Court judge. Earlier the salary used to be equivalent to the Supreme Court judge. Now it has been made equivalent to the cabinet secretary. So it has degraded the position of the Chief Election Commissioner and the election commissioners, right. It will be for the period of 6 years and the 65 years, that you must be knowing. The election commission can be removed from the office on the recommendation of the CEC. They may resign at any given point to the President of India, right. And this point is also very important, just like earlier ones. So they can be removed only on the same manner just like the Supreme Court judges. So that is there. Then common electoral roll, not much important. There are two kinds of rolls, that are general electoral roll and the separate electoral rolls, right. So that is only provisions. False declaration during the filing of the nomination for the election. Representation of People's Act 1951, it says under the section 125 of the Representation of People's Act that if any person is filing for false information, means false information regarding the asset and liability, false information regarding the criminal cases, how much they have, civil cases they have. So such kinds of things, if they are filing, then that will be declared, they will get a punishment for that. Simultaneous election, recently the former President Ramnath Kovind has this recommended that there should be simultaneous election in our country, both for the Lok Sabha, state assemblies as well as the Panchayati Raj system and the urban local governance. There should be simultaneous election throughout the country at every level. So that is there. So debates are going on. There are high probability that from 2029 this simultaneous election will be there. Minimum age for the voting, everyone knows that for the Lok Sabha it is 25 years, Raj Sabha it is 30 years, and for the member of legislative assembly is 25 years and the legislative council it is 30 years. Legal safeguard in case of the convicted candidate. Representation of People's Act 1951, it means this section 8 of the Representation of People's Act, it talks about the disqualification, how on what basis disqualification can be done. For example, section 8(3) of the Representation of People's Act, it talks about that if a person is has been convicted for more than 2 years, that person can be disqualified for the number of years that person will be going to the prison plus 6 years, right. So if the person goes for the 4 years, so plus 6 years, for 10 years that person will be disqualified, right. And there will be immediate disqualification of the person once the person gets convicted for more than 2 years, just like and this has been said using the Lily Thomas case. Poll expenditure, there is a limit on which means maximum limit that is being put, that a candidate will not expend more than that limit. For example, in case of Lok Sabha, in bigger constituency it is 95 lakh, in a smaller constituency it is 75 lakhs, right. Similarly, in the legislative assembly, for bigger it is 40 lakhs and for the smaller assembly, for a smaller one it is 28 lakhs. And section 77 of the Representation of People's Act, it says that every candidate will have to have a separate account of separate and the correct accounts of the all expenditure incurred between the date on which the declaration has been made. So that is there. InCode is not much important. InCode has been, it is a software which has been made by the Election Commission of, launched by the Election Commission of India, right. VVPAT, not much important. For the 7 second it will be showing that how much the voters has voted to whom. Star campaigner are the person which is being declared by all the political party, whether it is recognized or unrecognized. Recognized can declare 40 star campaigner, unrecognized can declare 20 star campaigner, and this star campaigner will go to different places and campaign for the political party. So that is there. These things are written inside the Representation of People's Act 1951. Then we had this Indian Penal Code, CRPC, and the Indian Evidence Act. These things has been renamed and several provisions have been removed as well as the added in this kinds of thing. So that is there. And this thing is Nari Shakti Bandhan Constitution Act 2020-23. So this is the reservation of the women, 1/3 seats in the Lok Sabha, Legislative Assembly, as well as the union, in the union territories also. This 1/3 seats will be reserved for the women section. From that, after the next session, there will be a delimitation commission, and after that, that will be implemented. Means after the next census, it will be done. Then OTT regulation, not much important. Multi-state cooperative society, not much important. भारतीय न्याय संहिता, IPC का नाम चेंज करके भारतीय न्याय संहिता किया गया. भारतीय नागरिक सुरक्षा संहिता 2023, it has been made by changing the name of the CRPC, and भारतीय साक्ष्य अधिनियम, it has changed the name of the India's Evidence Act 1872. यहाँ पे भारतीय न्याय संहिता में जो सबसे ज़्यादा इम्पोर्टेंट है, so it removes the offense of the सेडिशन. सेडिशन के चार्जेस, जिससे बहुत सारे फ्रीडम फाइटर सबको पकड़ के जेल में डाला गया, वो सेडिशन की चीज़ें जो है वो हटा दिए गए हैं. अब CRPC में ये इम्पोर्टेंट है कि डिटेंशन ऑफ द अंडर ट्रायल्स में जो फर्स्ट टाइम ऑफेंडर्स होंगे वो अगर 1/3 maximum period of imprisonment if they have served, then that will be can be released on the bond. If the person has committed a heavy crime, then and have spent at least half of the maximum period, then that can be done. right? And if the person has committed offence like the death, for which the death, life imprisonment and such things has been awarded, then in that case the person, these kinds of things will not be applicable, right? Bharatiya Sakshi Adhiniyam, so in this that has been made that the electronic or the digital records or evidence have the same legal effect as the paper record. So this will now act as the primary source of record. Earlier it was acting as the secondary source of record. So now it has the it is taken as the equivalent to the paper record. So that is there. Mediation Act 2023 has been passed. Mediation, you know that a third person will be there. If the disputes is there, will be there between the A and B. So a third person, C, will be there. This third person will try to have a communication between this A and B. This third person will not give any kind of decision, but it will help this A and B to take a decision, right? So that Mediation Act has been passed. That what kind of mediators will be there, how much experience they will have, how much the timeline will be there. Telecommunication Act, not much important for the prelims point of view. It has replaced these kinds of acts, Indian Telegraph Act, Indian Wireless Telegraphy, Telegraph Wireless Act, and it has amended the TRI Act 1997. Few important points is there. Spectrum allocation will be on the basis of auction only, except few things like the National Security, Disaster Management, Satellite Service. If for these things spectrum has to be issued, then that can be done without the auction also. Plus OneWeb, Starlink, all these things, the allocation of spectrum can be there. OTT platform is not regulated under this, and also the users will have lots of privacy using this Telecommunication Act 2023. Internet shutdown, if the internet shutdown takes place, it is the violation of the fundamental rights of the citizen of the country. So the internet shutdown cannot take place indefinitely, right? And if any internet shutdown takes place, that has to be for the limited period only, and it is subject to judicial review also. So that is there. Delimitation Commission, everyone knows this Delimitation Commission. The Delimitation Commission, it is based on the what does this do? It decides that what will be the area of the constituency on the basis of population. It will decide on the basis of census, right? So Delimitation Commission are being set up time and again for more than 4 times. This Delimitation Commission has been set up, and on the basis of census data they will be deciding whether it is a constitutional body. No, it is not a constitutional body, it is a statutory body because it has been formed through the Delimitation Commission Act. But there is a constitutional backing of Delimitation Commission, that is Article 82 of the, and Article 170 of the Constitution, which provides that the number of the seats in the Lok Sabha and the State Legislative Assembly respectively, as well as the division into the territorial constituency, shall be readjusted after each census. But there is no word written Delimitation Commission inside the Constitution of India, so it is not a constitutional body, it is a statutory body. So that is there. Directorate Enforcement. One thing you have to remember here is that Directorate of Enforcement, it is coming under the Department of Revenue, Ministry of Finance, and it is headed by the Enforcement Directorate, who is appointed under the Central Vigilance Commission Act 2003, right? ED has been very much in news recently. So they are implementing Coffee Posa Act, FEMA Act, PML Act, means Prevention of Money Laundering Act, and FEO Act, that is Fugitive Economic Offenders Act 2018. And they will have all the power to seize the asset, power to summon any person, power to arrest, right? So such kinds of things will be there in this act. And there are Central Bureau of Investigation, CBI. CBI is not a constitutional body, CBI is not a statutory body. CBI takes the power using Delhi Special Police Establishment Act 1946. It is a act before the independence of India. It has been formed using the Santanam Committee recommendation, right, just like the CBC. Both has been formed using the Santanam Committee recommendation, and it will be headed by a director who is appointed by the committee, PM, Lok Sabha Speaker, Lok Sabha Speaker of the Lok Sabha, and the Chief Justice of India. Right. CBI handles cases like the anti-corruption, economic crimes, special crimes, suo motu cases. But CBI does not handle the cases regarding the terrorism. right, that is specifically given to the National Investigating Agency. I hope that is clear to you. Rest not much is important. Right. 75 years of the National Cadet Corps has been there. It has been formed with the National Cadet Corps 1948. So that is there. It comes under the Ministry of Defence. Appointment Committee on the Cabinet. So most of the appointments which is being done for the Central Secretariat or the public enterprises or the bank or the financial institution, so that is being done by this Cabinet Committee on the Appointment. It will be chaired by the Prime Minister, and the Union Home Minister is also a member. Rest not much important. Centennial anniversary of the Press Information Bureau. One thing you have to remember, that the Press Information Bureau is a more than 100 years old. So it was formed in the 1919 only in the Simla, right? So that is there. And the function of the Press Information Bureau is to interface between the government and the media. National Investigating Agency, it is a very important body. NIA, it has been formed in the NIA Act of 2008 after the 26/11 attack, right? So that is there. So it is a federal counter-terror agency, right? Therefore, terrorism cases are only handled by the National Investigating Agency, right? They will have the jurisdiction about other services in the government where they are being posted. And one more thing you have to remember regarding the NIA, they are also handling cases like the cyber terrorism, right, and the cases outside India also, right. So that is their Cabinet Secretary, appointment of the Cabinet Secretary on the basis of seniority merit basis. And one important point you have to remember is for the prelims, that is Cabinet Secretary is also the head of the Civil Services Board. Lokpal, you must be knowing that Lokpal is an ombudsman which is for the anti-corruption purpose, and it has been formed with the Lokpal and Lokayukta Act 2013. At the central level there is Lokpal, at the state level there is Lokayukta, right. Lokpal, it will be appointed by the selection committee. The selection committee will have the Prime Minister as the chairperson, Speaker of the Lok Sabha, leader of opposition in the Lok Sabha or the leader of the single largest party in the Lok Sabha, Chief Justice of India or the judges nominated by him, right, and one eminent jurist. Composition, there will be 8 members, and at least half of them should be belong from the scheduled caste, scheduled tribes and the other backward classes, minority and the women. One important point is that 60 days for the completion of inquiry and 6 months for the completion of the investigation of the CBI is required, right. Another point is that the Right to Information Act. Right to Information Act, it is coming under the Supreme Court, directed by the central and the state government to fill the vacancies of the CIC. So Right to Information Act has been passed in 2005, and this is basically to give information to the people of the country. Anyone can file right to information to whichever department or the ministry they want to take information, right. So that is there. There are Chief Information Commission which has been set up using this Act, Right to Information Act only. It is not a constitutional body, it is a statutory body. It is appointed by the President on the recommendation of the committee, that is Prime Minister, Chairman, leader of opposition in the Lok Sabha, and the Union Cabinet Minister in the Prime Minister, nominated by the Prime Minister. One very important point you have to remember is 3 years and the 65 years. Mostly the cases is 5 years, right, but for the Chief CIC it is only 3 years, right. For example, Election Commission, it is for the 5 years. The Finance Commission, it is for the 5 years, but CIC remains for the 3 years only, just like the NHRC, right. Then measures taken for the consumer protection, not much important. Scheduled caste and the other traditional forest dwellers Act, Recognition Act, SC/ST Act, it has not been implemented properly. The nodal agency will be the state government or the union territories, that is there. Lots of power will be there with the Gram Sabha, right. Article 311, not much important for the prelims. Ranganath Mishra Commission, Let's see Article 311 also. The civil services cannot be dismissed or removed on by any authority subordinate to the authority by which he was appointed. See Article 311(2). Please read this, though not much important for the prelims point of view. Then one important committee was there, that was Rangnath Mishra Commission. Rangnath Mishra Commission, it was there set up for the religious and linguistic minority, means they have to recommend for the religious and linguistic minority. But the thing is, whatever they have recommended regarding the scheduled caste reservation for the Dalits to convert to the Christianity and the Islam, means scheduled caste people who has converted into the Christianity or the Islam, should there be reservation provided to them or not? So whatever the recommendation is being provided by the Rangnath Mishra Commission, so that was not accepted by the government. Therefore, the government has set up a new commission, that is Chief Justice of India, G.B. Balkrishna Commission, and using this they have been given the time of 2 years, and they will be looking up whether the scheduled caste status be granted to a new person who has been historically belonged to the scheduled caste but has converted to the religion other than the Hinduism, Buddhism and the Sikhism. So this you have to remember. If at all UPSC prelims will ask regarding this commission, this sentence you have to remember, right? So we have covered this topics in revision formats. Obviously we didn't go into much details of it. In the starting we have gone into much details, right? But the thing is, you will have to read this document 1 or 2 times for the revision for yourself also, right? Please do read it. There are highly likely that this case snippet booklets will provide you 10 to 15 questions. So please give time for this. At least one day you can give, and it is not a bulky document that it will require lots of time if you have already covered current affairs in last 1.5 months, means 1.5 years, right? So thank you for very much and all the very best.